Good afternoon. Welcome to the September meeting of the Rehoboth Beach Board of Adjustment. Roll call to my left, please.
William Pearlstein.
Jan Conacy.
Edith Heron.
Mark Saunders.
Fred Townsend, Board Attorney.
And Barry Brandt. And was the meeting and public notices properly posted for today's case?
The agenda for the Board of Adjustment regular meeting was posted in City Hall and on the city portal on September 16th. It was amended and reposted on September 17th, 24th, 25th, and 27th. Public notice for case number 0828-08 for the property located at 2 Rehoboth Avenue was posted in City Hall and on the city portal on September 3rd. The public notice was published in the Gazette on September 10th and September 13th, and Delaware State News on September 11th and September 13th. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, signage posted on the property. That's all I have.
Thank you, Ann. We received additional public correspondence this morning. Ann sent it out. Consists of 3 letters, some with attachments. Did everyone on the board get a chance to look at it? Just like an affirmation, please.
Yes, I have.
Yes.
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 And I reviewed it as well. Thank you. Okay, and we have a little housekeeping to do. We have minutes from August to approve. Did everyone get a chance to review the minutes that Ann sent out?
Yes.
And any changes or?
I had just a very few type changes, which I shared with Ann, but nothing that changed the content.
Okay.
Did that include any of the reference in the paragraph concerning you on page 3 that said exceptional practical difficulty is number 1, when that should be number 4, I believe?
I wasn't sure about that, so.
Okay.
I couldn't, but Ann always says she takes exactly what you say verbatim, so I figured maybe I misstated, and there wasn't an easy way to change that. I didn't even bring that up with her this morning.
Okay.
When I went over
If
that.
you're okay with
Yeah,
it, that's fine.
I wasn't sure whether I said it that way and I was incorrect, or whether it was 4.
Okay.
But what do you think we should do with that, Ann?
I can listen to it again.
Okay,
That makes it appropriate for us.
okay. Okay, thank you, Bill.
Okay. May I get a motion to approve the amended?
I move to approve the
minutes?
amended minutes.
Seconded.
Okay. All in favor?
Aye.
Aye.
Barry, I'm abstaining since I wasn't at that meeting.
Understood. Thank you, Mark. Okay. We do not have any notices of decisions to approve today. In today's case, we only have one case today. The board will apply quick check factors that Delaware recognize as guidance for the Board of Adjustment. Under Delaware law, an applicant for an area variance must prove that the requirements create an exceptional practical difficulty. To determine whether an exceptional practical difficulty exists, the board must weigh the following 4 factors: the nature of the zone where the property lies, the character and use of the immediate vicinity, whether removal of the restrictions on the applicant's property would seriously affect the neighboring properties and their uses, and number 4, whether failure to remove the restriction would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This standard is satisfied only when difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Today's case is different than most cases. We have a request for clarification on the allocation of the previously approved FAR relief. We have a request for the board's declaration of code interpretation for loading docks, permissible heights applicable to antennas, railings, and other objects, and we'll get that clarification on other objects when we go through it. I know I can speak for my fellow members by saying I look forward to hearing the applicants and the city's position as to the limits of our jurisdiction. Our last topic, we'll get to the actual variance request for minimum parking spaces required. Finally, I will remind the board that we are not here today to rehear the decisions from the previous Board of Adjustment decision of allowing FAR of 3.0. The Board of Adjustment approved an application for a FAR increase of 50% from 2.0 to 3.0. This FAR increase was approved in 2021. However, we are being asked to clarify whether the board intended that the FAR allocation be restricted among the upper 3 floors of the hotel. Everyone who chooses to speak today will be required to give their testimony under oath. I will ask our counsel, Mr. Townsend, to administer the oath. We do not have a court reporter present, so if a transcript of this hearing is ever required, our secretary will have to work from the tape recording of this meeting. I used the word tape recording, imagine that. Please keep your voice up, speak directly into the microphone, and please no cross-talking conversations during the hearing. If at any time the technical team or any board member or Ann feels that we are not getting an accurate recording, we will just simply stop and remind the speaker. I'm just going to look up today and see if there's anyone in the audience who wishes to speak for or against today's case. Just so, okay, we have, all right, thank you. We are going to, as you all know, if you speak, you'll be asked to be sworn in. And we are going to hold public commentary to 5 minutes. We have a timer up here, and we just want to get through the meeting today with giving everyone. We believe 5 minutes is fair enough. After the applicants and public finish speaking, we will close the public participation portion of the meeting, and no further public comments will be heard as the board discusses the case. Before we get started, I'd like the public to know that on occasion, the board members may use electronic devices. The personal devices are being used to allow the board members to look at detailed drawings that may have been submitted with the case. The board at no time will be utilizing a device to communicate with anyone. Okay, moving on. We have no old business and our new business today. I just wanted some clarifications. To manage our time as efficiently as possible, I suggest we go in the order of hearing the FAR clarification first, dispose of that before moving to the next set of topics involving height ordinance and the loading docks requirements. And then we can finish with the variance application. So at that, I will, we're going to, yeah, oh, good point. Yeah, we're going to allow the public to speak on each item. So this meeting may come across as repetitive. If you want to talk about the height, well, you'll have a time to talk about that. So again, we're going to go in the following order. We have a lot of material to cover. Permitted floor area on individual floors, then loading docks, then antenna, railing height, and then finally variance for the minimum parking. For the first clarification topic, I'm asking the applicant to speak first. For the variance topic, we will ask the building inspector to speak first, as we normally do. And then, like I said, we will go on to public commentary after our question and answering. So with that, I am going, go ahead, Jan, I'm sorry.
Okay. For the record, I want to acknowledge that for the initial hearing of the Bellhaven by the Board of Adjustment, I recused myself. I did not do so because I had an actual conflict of interest, but because months prior to that, before I was appointed to the Board of Adjustment, I and others attended a meeting hosted by the applicant to review the plans of one of the earliest versions of the Bellhaven Hotel. That meeting left me feeling uncomfortable in sitting in on that case, as I had been their guest at a preview of what they wanted to achieve at that site. That was years ago. Today, I can say with absolute conviction that I can perform my responsibilities as a board member without any bias stemming from that 2019 meeting or anything that has occurred since. Thank you.
Thank you, Jan. Okay, with that, we will ask the applicant to come up, and we can start on the FAR allocation topic.
Thank you, Mr. Chairman. My name is Richard Forston on behalf of the applicant, and let me thank you for your introductory remarks, and let me thank Ms. Conacy for her remarks as well, and we have confidence in what she said. This plan came initially, this hotel came before the Board of Adjustment back in late 2021, and then I think it was January 2022 when the written decision was finally issued. And the goal here, because I know some of you weren't here at the time, but the Papa John family has owned this property since 1938. They owned the Belhaven Hotel. It had to be torn down as a result of the 62 nor'easter. And now the current structures that are there, they're past their useful life. So in looking at various development options, we could put a hotel on the site, but it would with surface parking, and that would take away the stores on the boardwalk and on Rehoboth Avenue. Mr. Papa John doesn't want to do that. You know, he loves the city. He grew up in this city, and if you've never had a chance to talk to him about what life was like in the 30s or 40s during World War II, it's fascinating stuff. And so his goal is to build a new structure that will be iconic and a landmark for this city. He wants to keep the boardwalk experience. He wants to keep the retail. That all requires underground parking. To justify underground parking, we needed an increase in the permitted floor area. And so back in 2021, this board determined that there was exceptional practical difficulty and granted an increase in the floor area ratio from 2.0 to 3.0, and thank you for that. We thought that's all we needed. That's all, you know, the building inspector at the time had told us. That's all the previous building inspector at the time had told us. As it turns out, while there is a 2.0 floor area limitation for the overall structure, there's also language in the code a few sentences later that says the individual floors have to average 50%, which adds up to 2.0, right? And that no one floor can exceed 75%. Nobody at the Board of Adjustment, nobody at the city, and certainly my client did not realize that perhaps they should get a second variance. They only asked for the one, it was granted. They moved on to the Planning Commission. And, you know, I'm not here to criticize or pick on the Planning Commission. They did what they did. I'll say I was disappointed in some of what they did. But one of the things they asked for was clarification from this board that in granting the increase in FAR from 2.0 to 3.0, that also meant that individual floors, the average of those individual floors could exceed 50%. And back in 2023, on the other side of Rehoboth Avenue, what I'll call the Grotto Hotel, also came before this board for a similar variance. And they only made the one request, just like we only made the one request. And the board granted them an increase in floor area ratio. But importantly, because the issue had just been raised, I think, at a previous Planning Commission hearing, in its written decision involving the Grotto Hotel, the board said the following: having found that an increase in permitted FAR from 200% to 275% is appropriate, it follows that an increase in the maximum FAR from floors 2 to 4 is presumed appropriate. Otherwise, the increase in total FAR would be meaningless and unachievable. Accordingly, the 76% FAR increase may be apportioned among floors 2 to 4. And I think that was exactly right. I think it's common sense. But the Planning Commission wanted you to essentially make the same statement here, that in granting the increase from 2.0 to 3.0, the individual floors could likewise increase in size. And I will point out, I mean, that shouldn't come as a surprise to anybody on the board who was here then or really now, because we submitted drawings of the hotel with our application, and those drawings showed floors that all exceeded 50%, and in fact, added up to 3.0, or actually 2.99, I think, but 3.0. So we simply seek the clarification in accordance with the Planning Commission's instructions I'm happy to answer any questions. I don't know that there's much more to really say about this topic.
Okay, thank you. I'd like to give the building inspector, if you have any response to this or any input. All right, Alex.
Hey, good afternoon, everyone. It's a pleasure to be here. I just wanted to point out that, sorry, it's closer. All right, thank you. So I just wanted to point out for the record and everyone's information that there is a building inspector report with, in relation to the off-site, off-street parking item. The other 3 items were detailed in Matt's previous building inspector report. So just for purpose of efficiency, we didn't feel the need to recreate additional building inspector reports for those items. You know, no intent to be uncooperative there. We're just trying to be efficient and navigate this procedural posture. And so I think that for the off-site parking item, there is the, sorry?
I didn't think we were dealing with that
Oh,
issue.
no, I was just pointing out as a opening point that
We don't need that.
we have a report for that item. And, you know, that's more of a classic variance request. But for these other items, Matt didn't prepare any inspector report. I'm not sure if he really has much to add, but I'll defer to him.
I do not.
I have a question for Matt. Matt, I'm assuming that your inspector report from June 28th, 2023 still stands from everything I understand.
Yes, ma'am, that's
Yeah,
correct.
about this issue. Has there been any change that you have felt or needed to say? Is there anything you need to say that makes any nuanced difference to that report at that time from June 2023?
Do you mean with respect to this?
With respect to this issue?
No, the report that we issued was comprehensive and touched on all these issues.
Yeah, it
I'll
was.
just defer to that report.
Okay, so there's nothing about lot coverage or anything else that it impacts it? Okay,
Correct.
thank you for the clarification.
No problem.
And I do have one question for the applicant, if I may ask that. I didn't see any new pictures of the layout. The most recent one I had was 2021. Do you have any, and they still show a number of the features that we haven't yet spoken about, but I didn't know if you have, as part of your presentation, new aerial views or new schematics for anything, Mr. Forston.
We have, yeah, we put on the record, and we have with us to show later, to the extent the board wants to see it, both the pictures from the original 2021 presentation, and we also have, I'm going to say, the tweaks that have resulted from the Planning Commission process. Substantively, the view from the street, the view from the outside the building is the same. I mean, it still has the same 4 walls, it still has the same height. There have been some tweaks. I can show them to you now. I was planning on showing them to you later.
No, I was just asking if you had such a thing, because if you had such a thing and it impacted what we're talking about here for any reason, I thought it would be good to share it at this time.
No, the floor area ratio stays the same as it was. There's been some adjustment on the internal hallways, and the number of rooms has gone down, and we'll get to that. But from the externals, it's all the same, and it doesn't impact this question.
Thank you for the answer. And one other thing I wanted to say to Matt, I thought that your March 24th, 2024 was the joint building inspector WM report was excellent. The calculations were fantastic and really helped at least me and maybe my fellow board members in understanding where we were on this issue and many other things, but we're only dealing with this one now. So thank you again for your calculations.
You're quite welcome. There's a lot of work that goes into these reports, for sure.
I do know that.
Matt, I had a question for you. This is almost historical. Do you have any insight into why you might think these additional allocation requirements may have been made into zoning code? I mean, it would give the impression that it would lead to straight-up boxes. Any historical?
No.
I mean, I kept rereading the code over and over and over, and I'm just saying, I couldn't get there.
It promotes a box.
Okay.
Well, can I add something to that? In 1980, Norman Chagru made a comment that if we didn't do something about our building code, we would end up with rectangular boxes all the way down Rehoboth Avenue, and it would be a canyon. Well, We haven't done anything with our building code, and it still allows that to happen.
Okay.
So that's a whole nother issue.
Okay, thank you. They were my questions to the building inspector. Bill, do you have any?
No, I don't.
Okay.
I just have one question. Am I correct that if you are granted this variance or clarification, that it will not affect the density of the hotel? It will still remain at the same 92 rooms?
Correct.
Thank you. That's my only question.
And I have a question. I'm going to start with the applicant, and it may lead to another witness being called. And as the chairman, I'm allowed to call witnesses if they are present. It's a question on the FAR allocation to the Planning Commission Council, if they are here today, if they're willing to come up.
He's here.
Okay.
Afternoon.
Thank you for. I watched the July 12th, I think it was, Planning Commission, the second day of it, and I heard throughout the whole course of the meeting commentary from the Planning Commission on why things were, for safety's sake or whatever, trucks on Wilmington Avenue, but they remained silent on the FAR allocation. Are you willing, or do you have any insight as to why that was a silent topic, so to speak?
So first of all, Luke Mehta, counsel for the Planning Commission. I'm not really here to testify as a fact witness, with all due respect. I'm here to talk about legal issues raised in our amicus statement, which I think has produced already helpful concessions, but I can't really speak factually on behalf of the Planning Commission. It's a body of 7 people or 9 people.
9.
I think the written notice of decision speaks for it.
Okay.
Speaks for itself.
Okay, it was just something that I observed. Okay, I have no further questions on the FAR. Yeah, thank you.
Thank you.
No other?
Nothing further from me.
Okay. So at this point, we're going to ask the public to speak on this topic. Again, we're staying focused on the FAR allocation, and we get done with the commentary. The board will close public comments, and then we will discuss it among the board. So anyone wishing to speak on the FAR allocation? Okay, no one raised their hand, so there is none. So we will close down the public commentary of the FAR allocation and start discussing this amongst the board.
I don't have any problem with this one.
Okay.
No, I think it's implicit in the earlier decision, actually finding a fact, number 1 on the earlier decision, so that the FAR 3.0 would generate total square feet of 115,475. So without having been a member, it seemed to me that it was clear that the members understood that the individual floors would be above what otherwise the 50% and 75%. I don't think there's any other way to read that decision.
Thank you.
I would just like to ask Fred, I agree with what Bill said, but I'm wondering if a variance would be a better avenue than a clarification. So clarification requires 4 of us that weren't on the board to discover what they were thinking at the time. And I'm wondering if a variance would be cleaner. I'll look to Fred for the answer.
Well, the applicant is not here before saying they have an exceptional practical difficulty that they want relief from the code for. So the applicant would probably not, the applicant is really not here, but for the fact that the Planning Commission has conditioned its approval on this clarification. So I don't think it would be appropriate to analyze it as a variance or as an appeal. It's just simply a desire to make it, for this board to make it clear that what action it took back in 2021 was intended to have the effect of granting relief from any prohibitions on a per floor basis for lot coverage.
I can say, Mark, as a lawyer, it is not unusual for a judge or a court to be asked to interpret an earlier decision by the same court where, for example, in a court of appeals where there are 3 or 5 or 7 or 9 members case the Supreme Court, to interpret one of their earlier decisions. It is, even though they were not members, what you're doing is sitting as a expert, which we are at this point on this stuff, saying what's a reasonable interpretation of the earlier decision by this body as if we actually had made it.
I'm comfortable with that then.
Can I ask Fred, how do you, when you're making a clarification, how do you make a motion?
So we could ask for input from the parties on that, but it seems to me that the motion would be something to the effect that we're declaring that the prohibitions related to lot coverage that might extend to the upper floors of the hotel were meant to be relieved from in the course of granting the variance of 3.0. There's probably a better way to state that, and maybe we should give parties an opportunity, or at least, the city and the applicant to confirm that that should be acceptable.
Mr. Chair, can I just address this issue briefly? First, I want to make clear that back in 2021, the board did find exceptional practical difficulty with respect to FAR for 2.0, and so that's why they granted the increase to 3.0. That same, if the board had focused on this individual floor question, the same logic that found exceptional practical difficulty with respect to 2.0 should also apply to the individual floors, because you can't really have one without the other. I understand your question. I thought it was a good one. Are we interpreting a previous decision? Are we making a separate finding? I think you're interpreting the previous decision, but the same logic that informed the grant of the 3.0 also, I think, supports the individual floors. As to Ms. Conacy's question about what kind of motion do you make? I mean, I think it's a common sense motion, and if I was sitting on the board, I would say something like, move that the Planning Commission's request for clarification is hereby granted, and that in granting the overall increase of FAR from 2.0 to 3.0, that increase also covered the individual floors, and the floor area can be apportioned the additional floor area can be apportioned amongst those floors as determined by the final site plan or something like that.
And we also have the language that was quoted to us from the subsequent decision involving the hotel across the street.
Correct.
And I think that language would cover it as well, which is quite similar to what was just stated by the applicant.
Okay, but before we move to a motion, I want to make sure all the board members get to speak. Edie?
I didn't have anything to add. I'm in agreement as well. And even though we are not a precedent-setting organization in any way, I do believe that that the decision that's being mentioned about number one Rehoboth that we made a number of months ago, and the language we used then is applicable in this case. So I was going to suggest that perhaps we look at that as a motion basis if we wish to do that.
Okay, and,
I can do that.
okay. When I looked at this topic again, I tried every which way to, read into that, and it is a common sense topic. So I stand by the building inspector's report, affirm what he has said, and agree that the applicant would be, allowed to, utilize the FAR of 3.0. I just couldn't figure out a way to do the 3.0 and adhere to those additional codes. So I'm in support of the building inspector for this. So can we get a motion?
Well, I'll try it.
Well, Fred, you have it right in front of
Yeah,
you,
maybe
right?
Fred, but he can't make a motion.
Right, but he can pass it.
You could pass it to somebody.
Well, I can read it.
Yeah,
Yeah.
okay.
Well, that's a lot.
Well, the language that I was proposing to read was the same language, but we would modify it slightly from the one Rehoboth decision.
Well, you want me to give it a try and see what people think?
Sure. Go right
Okay.
ahead.
I move that we clarify the Board of Adjustment's decision for the applicant in allowing the 3.0 FAR to apply not only to the hotel as a whole, but to individual floors to be apportioned among the floors. I tried that. See, is that enough, or do we need more words or fewer words, or?
I think that's sufficient.
Can I ask a clarification question? Does that mean that it's apportioned equally between the floors as it is in the plans now, or is it, you know?
No,
isn't.
that wasn't discussed at the time, and so I think that would be going beyond a clarification if we were to impose some kind of restriction on how that additional FAR could be spread among the upper 3 floors. So, and in the Rehoboth 1 decision, again, we didn't impose floor-by-floor limitations either.
I mean, the plans show it floor by floor, but
you don't want to, you're not putting restrictions on that.
no, I was clarifying
Right.
Edie's motion with Fred to you know,
So it sounds like you'd like the group to consider whether we should somehow link the developer's plans to this motion and say as shown or something, as depicted before us or before the Planning Commission. I think that's dangerous. I think we might find that there is some opportunity there or some mishap that might arise that would mean they might have to come back here again over this. So we didn't impose any kind of limitation like this in the other instance. It's not binding on us. There doesn't seem to be any public outcry or desire from the Planning Commission that we do place specific limitations on the allocation of the FAR among the upper 3 floors. So I think the cleanest thing to do would not be to try and impose such a restriction.
And Jan, if I can draw your attention to Matt's great building inspector report of March 2024, on the last page of it, page 10 of 10, there's actually the FAR is calculated by floor. Unless I've misread this, it's as to what they have proposed and then calculated.
but that doesn't mean that's what they have to do. Okay. I've been around a long time, Edie.
Sure.
You know, I mean, trust but verify, you know, and
Yeah,
that's one
right.
of my considerations.
I
We've sat
see.
here and we've listened to people tell us the square footage of a house was 1,800 square feet.
Right.
When it was 2,800 square
Right,
feet.
right.
So, you know, I just,
Right.
that's why I asked the question.
What is it that you're proposing, Jen?
Nothing, I just was asked a question.
Oh,
If you can require that it, just like we did on the coast, we required that the addition match the plans that were shown to us. If you recall, the 4 rooms, they were behind like a parapet or something. And we required that it do that. That's all I'm asking.
Yeah, I'm a little bit concerned if we, you know, with respect to Matt's report on page 10 of 10, I, you know, agree with that. It's giving the calculated. But if one of these numbers changed ever so slightly, would we have to
I'm
come back
fine.
here?
I'm
Okay,
just
okay.
fine.
Would they not have to go back to the Planning Commission if they made a significant change?
They might, and then this decision might somehow create an obstacle that it doesn't seem we even intend to create. Right.
Right.
Yeah, I would prefer, well, if I could speak to Edie, you know, well, I can't second a motion, but
Right.
what you said.
What I said. I move what I said. Okay.
You have to say it again.
Oh, gosh. We don't have a second yet, but.
No, we don't have a
and maybe
second. We
don't-
need we need a
maybe-
second.
Maybe people aren't agreeing, so.
Oh, I seconded. I thought you were just still contouring it.
No, I did not hear your second.
I didn't, but I will now.
Okay,
Oh,
so,
okay.
okay, so can you repeat that again? Make sure we
Oh, gosh.
have it right?
Could you read it back, Ann? Is that, no?
No,
Okay,
no,
let's
she can't
see.
do that.
Oh, gosh.
One if it helps you.
No.
All right.
Gosh. Let's see. I move that we allow the applicant to use the 3.0 FAR across individual floors within the hotel. That was the bottom line of it, but I think I had more words then.
Yeah, and without restriction.
Oh, I didn't say that, but okay, without restriction. Okay.
May I get a second on that motion?
Second?
Okay, all in favor? I'll start with Bill.
Aye.
Jim?
Aye.
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 And you, okay. So that moves, that passes. I don't know. It's just- Okay, let's move on to our next, I have to get my notes organized here. We're going to move on to the second topic, which is loading docks. So again, I'm going to ask the applicant to speak first, and then we will ask Matt to, if he has any commentary on that, and then we'll go to the public.
Loading docks is what you said?
Loading docks.
Okay, thank you. Okay.
Thank you, Mr. Chairman, and thank you for the board for that previous vote. So one of the issues that came up during Planning Commission review was the number of loading docks. The code clearly requires a loading dock for the hotel. Incidentally, none of the current retail establishments that are there now have a loading dock. Candy Kitchen doesn't have a loading dock. Coors Ice Cream doesn't have a loading dock. Grotto's doesn't have a loading dock. There is no loading docks currently serving any of the retail locations.
Excuse me, may I ask a question? Are you using dock and berth interchangeably?
Yes.
Because a lot of the wording within this code says loading berth.
I'm sorry.
I assume so. No, you don't have to be sorry. I just want to be sure we're all talking about the same thing.
No, look, I'm a lawyer. I should be that precise, so I
Okay.
appreciate that.
All right, thank you.
But I apologize. I will continue to refer to it as a loading dock, but I mean berth.
Okay.
So the code further says that a loading dock is required for any commercial or retail establishment, singular, in excess of 15,000 square feet. None of these retail uses currently exceed 15,000 square feet. Therefore, and none of them will ever be in excess of 15,000 square feet, because if we tried to do a retail establishment in excess of 15,000 square feet, we would need a loading dock. And we'd either have to somehow find a way to add a second loading dock, or we would just have to tell our tenants who wants to come in, you can't come in that big. And the town would, I have every confidence, deny a building permit for a retail establishment that large in this Boardwalk and Rehoboth Avenue area. Now, the good news is that even though none of the current retail establishments have a loading dock, we said to the Planning Commission, and it's been our plan all along, that all of the retail establishments will be able to use the loading dock that is also being constructed for the hotel. And on the plans, there's interior corridors that gets you to the back of each of the retail spaces. And again, we described to the Planning Commission that, you know, someone at the hotel, maybe not the manager, but maybe his first lieutenant, part of that job description will be to manage the loading dock. It's not as though there are trucks constantly coming to these loading docks. You know, if they get used more than once a day, that would be a lot. And if they got used once a day, 7 days a week, that would be a lot. So that has been our plan all along. We only showed one loading dock. In his letter of June 2023, the building inspector wrote a letter, and he agreed with us on that. And as I said in my correspondence to this board, you know, once the building inspector issued an official decision, if you will, on that subject, your rules and Delaware law provide a limited time for people to appeal that decision, else it becomes binding. That decision was made public. It was actually copied to the Planning Commission. This was June of 2023, June 28, 2023. No one appealed that decision in June or July of 2023 to this board, and having failed to do that, I think the decision became final as a legal matter, and as I said, I am a lawyer, so I care about that. But even if no one had appealed that decision, I mean, I think this decision is still consistent with the code. And, you know, if you did watch all of the video, and there's a lot of all of the meetings with the Planning Commission, you would have seen some colloquies between myself and one of the Planning Commission members about whether one loading dock or two is required. As I say, retail establishment singular to me means a single user, not, you know, oh, if you have 5 retail establishments adding up to 15,000 or more. I mean, the language matters. But beyond all of that, so I think the language matters, the building inspector agrees. Delaware law also has a very important principle that says if the code is ambiguous and is susceptible to 2 different interpretations, the interpretation that favors the property owner is the one that controls. And there's plenty of cases to that effect. Most recently, there was a case involving lingo that involved, I think, the city of Rehoboth. There's a case involving Dewey Beach. There was a case involving Kent County. So for all of those reasons, I really don't think there should be any question but that only one loading dock is required. Now, as I said at the outset, I'm not here to pick a fight with my friend Luke Mehta or the Planning Commission about their written decision. Their decision simply says, because the code requires 2 loading docks, go to the Board of Adjustment and get a variance. But the code doesn't require 2 loading docks. They're simply wrong on that. And I don't think that this board can grant a variance where there's no need for a variance. I mean, if you want to do it, that's fine. I just need to get to plan approval. I need to get to the promised land, if you will. But I think that it would be a mistake to do that simply because the Planning Commission, having failed to challenge the building inspector's written decision, just like anybody else, became bound by that decision. And I think you would be setting a dangerous precedent if you did it there. I'm happy to, I think that's all I really have to say on the subject. It only requires 1, but I'm happy to answer any questions.
All right, thank you. And we'll turn to Matt, if you have any response.
No additional comments other than what our report offers.
Okay, so I have a number of comments for the loading dock. I'm going to start.
You mean questions?
Questions for Matt, yeah. Matt, can you explain what pro forma financial projection is when you calculated the loading dock? It was in the report.
That was brought up by Wallace Montgomery, and I would defer to them.
Oh, okay. So, and we've already heard that the existing building today along lots 2, 4, 17, and 18 on Rehoboth Avenue, it consists of 16,975 square feet. We do not have a loading dock back there. Correct?
That's correct.
That's correct, okay. Matt, are there local Rehoboth Beach or even national codes to specify the dimensions of a loading dock?
Yes.
Okay, and can you explain?
There are height requirements, width requirements, backing requirements for a truck to access the actual area, and there are state minimum requirements and nationwide minimum requirements for those type of structures.
And as proposed, unless I have to ask the applicant, what's the depth of that, the existing loading dock in the design? Do we know?
The depth of the existing...
Yeah, how far into the building does it go?
I'm going by memory, but I believe I'd have to pull up some documentation, but
Okay, or I can
it
ask the
meets the requirement.
Okay, to the applicant, do you know the depth of the loading dock?
We can call up the plan.
Yeah, because I didn't see a measurement on it.
If you could introduce yourself, and then I'll administer the oath, Mr. Follett.
Peter Follett, architect,
And your address, give us an address, your business address would be fine.
400 East Pratt Street, Baltimore, Maryland.
Mr. Follett, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Yeah, if you allow me, I can pull up the plan and dimension it. It's really,
Yeah,
that'd be
quickly,
great.
if you
Yeah.
see, I could not find it on it. What I'm looking for is Is it the depth of a tractor trailer body? Is it the depth of a tractor trailer plus the cab? That
There's
would
a
be, that would be about 72 feet into the building, I
The,
believe.
the required berth size
Yeah.
per our code is 45 by 12,
45 foot deep,
by
okay,
12 foot wide.
okay.
Okay, and I know we exceed it, so I'll give you the full number.
Okay, my concern would be, along with members of the planning commission, we're concerned about, a tractor trailer backing into that spot. I know this is on the singular, but even double would be double the problem of having a cab extend across the sidewalk. And I don't know if there are loading time limits for a tractor trailer in a loading dock, but it is a concern. This would be another question. So if there is a requirement for depth, is an applicant allowed to make it shallow? Almost just, a very,
So just to clarify what was said, there is a definition of loading berth. It's under 270-4, and it speaks to the minimum dimensions. So
okay,
the definition states in part, the minimum space on the premises where such facility is required shall be 576 square feet of usable area for each such berth, which shall not be less than 12 feet in width and 48 feet in length.
48 feet. Okay, so that's the, all right, that's the length of a tractor trailer body, but not the cab. So again, concern would be backing in, putting the in there, taking the cab on, taking the cab off. Okay, you've answered my questions there. And this is to Matt, there are different, from my knowledge of the code, that there are, around Rehoboth, loading and unloading zones, if you want to call the word, on Rehoboth, on Wilmington, I think on, I don't know if Baltimore has them or not, on that. Are these stores, would these stores be required to utilize the loading dock? Or would they be allowed to continue to utilize the designated zones? I mean, there's nothing that would force them to use a loading dock, is that correct? I mean, a UPS truck, a FedEx truck,
No, I believe your statement is correct. There is nothing that would actually force them to utilize the
they're
loading
following
dock.
code by using these areas on Wilmington and even Rehoboth Avenue. Okay,
That's correct.
all right, thank you. And,
Mr. Chair,
yes,
the dimension is 54 feet on the drawings,
okay.
right? And that's inclusive of the 48-foot truck.
48 includes the concrete that you would
Yeah,
offload.
If you look at the drawing here, the 48 feet is the crosshatch area.
Got it.
Right, and then there's another 7 feet in the front here, 6 feet here.
Okay,
So the dimension from the edge of the building to the back of the loading dock. is
okay.
54.
All right, thank you.
Sure.
And I think they were all my questions on the loading
Can
dock.
I ask a question? I don't quite know what we're doing here.
Yeah, so, yeah,
Okay.
there's a
Yeah,
sleeping bear in the room.
Yeah.
That's my real
Thank
lawyerly
you.
way
Thank
of
you
saying.
thank you for calling me out on that.
No,
No,
let
it's
me
fair.
put it on the record. We've got the decision of the building inspector, and we could ask Matt whether he's, and I believe he says he's not changed the view that only one loading dock is required here. The applicant only wants to put in one loading dock. So, and I really have to address this to Fred and maybe to Alex. I don't understand what our jurisdiction is here to be addressing this issue. Because does somebody have, do we have the right as the BOA to say, we disagree with Matt, even though there's nobody, the applicant is not appealing it because the applicant agrees. I believe that the Planning Commission can have a view, but they don't have standing any more than any, in my view, any more than any other entity in the city. We could hear them, but I don't, normally we're an institution of limited jurisdiction, to play lawyer. And I don't know what our jurisdiction is here to be considering this issue. So I've got to ask the city, maybe the Planning Commission's lawyer, if he's got a view, and Fred as to what it is we're doing here, because we're not supposed to be giving advisory opinions about whether we think Matt is wrong unless we have jurisdiction to do that without a live case. Because I don't see we have a live case here unless, Fred, you tell me that somebody else has got jurisdiction and has standing to put a matter in front of us.
So Mr. Brandt indicated in his initial remarks that he would be interested, and assume the rest of you would be, and you're proving to be interested in what the limits of our jurisdiction are. That was an invitation to the applicant and to Mr. Burns and to the public and perhaps to the Planning Commission to comment on their view of what our jurisdiction is. You're aware that our appeals jurisdiction makes us the final authority on the interpretation of the code. So generally speaking, when an appeal is brought, there is a difference of opinion between a perceived aggrieved applicant and the building official. That's the only occasion in which we've exercised that authority that I know of, or through experience with other boards. That's how it comes out. I think it's interesting to consider that appeals from interpretations of the zoning code don't go back to the Board of Commissioners generally, or maybe ever. I mean, that the boards of commissioners, even though they write the ordinances, they're not charged with the authority to interpret them in the end. In fact, it might, logically, you might think that they would be, but they aren't. That's our domain. So we know that this issue has arisen, and I think we need to hear from the parties on it, and then we'll see what we can make of it. And if there's specific questions, I imagine there will be. I'll help you sort them out.
Can I suggest that we limit the initial presentations to basically what we're, as lawyers would say, is jurisdictional issues, not whether we think it's a good idea to have 1 versus 2 or anything else, but frankly, what our jurisdiction is to be hearing this at all. Then for us to, I think ultimately we're gonna have to decide as a body whether we think we have the right to make any decision here, and then get into the merits.
Otherwise, we'll hear possibly testimony from members of the public who want to argue that 2 loading docks perhaps
Was a better idea.
would be better than 1.
Right.
Yeah.
But Bill, could we not, each of us has read the code, and we may have different interpretations among themselves of whether Matt is right or wrong. Having read the code myself, I disagree with Matt. I read it as this is 2 different entities, therefore 2 different entry points or freight docks or whatever they're called would be necessitated.
Well, going on Bill's presumption, I mean, I've been very uncomfortable about this all along, about us hearing on some of these requests. And, you know, I'm looking at Mr. Meadows about, I think that there are some things that are variances. And to clarification, the first one, the gross floor area and the floors, I don't have any issue.
Before we go on, though, let's hear from the parties, and then we'll make up our minds as to what we.
But should we even be hearing this at all?
Well, I
That's
think
my question.
that's what I said. But the parties need we need to give the parties an opportunity to speak to this.
I mean, there was a whole big discussion Friday about this, the Planning Commission versus the building inspector, and that motion failed. So now we're here, and, you know, I agree that there are some things that we should be hearing, but some of them are.
Well, we didn't get to that during the course of the initial presentation by the applicant, and we do need to hear that. So I think we should give the applicant an opportunity to speak. I think we need to hear from Mr. Burns and our building official. And as far as members in the public, if somebody's here who wishes to speak, and perhaps that might only be Mr. Mehta, not on the merits of whether 2 is better than 1, but what our jurisdictional limitations are, or whether our right to decide appeals and to interpret the code empowers us to make this determination today.
And just for clarification, Bill, maybe apologies for asking all these questions, but I needed a better education, and these questions did not affect my interpretation of the code, but I needed better clarification of that. So,
There's no rule book here.
well, we tried, but I didn't see the measurements on the diagram, and I wanted to understand what code called for on depth. And as Alex told us, there was another section. We don't go searching through the code book looking for things on that. So, anyone else have questions on the loading dock?
No, I have to agree with Bill. I don't think this is our jurisdiction.
Well, I don't know that Bill said that necessarily.
He asked if it was.
I don't think it is our jurisdiction.
Well, let's wait and hear before we announce what we think. Let's wait and hear from everybody and
Just ask one question to Matt to get on the record. Can you tell us approximately what the square footage of the retail non-hotel units is together? I had it here somewhere. I just want it on the record that it's more than 15,000. I'll re-ask my question. Do you agree it's more than 15,000 square feet?
Combined, yes.
Yes, that's what I wanted to hear. Thank you.
The only thing that I had was, I was going to ask Matt exactly what Bill asked him, which was, does he still agree, does Matt still agree with his June 28th report? And he's answered that question already. That was the only thing that I had about that at this point.
But the code clearly says that the Planning Commission has the final word on site plan review.
okay, but
Well, I'm the one who created this mess because I'm the one who filed the letter. So let me explain my thinking and logic, and I'll disagree with Ms. Connessy's statement, and I'll disagree with the Planning Commission, although I don't want to pick a fight with them, as I said. They don't have the final say on the meaning of the zoning code. I want to be clear about that. But let me tell you the position we found ourselves in after a year and a half of being in front of the Planning Commission. They issued a decision with certain conditions, comply with all federal laws, comply with all state laws. I mean, things obviously that we had to do anyway. They required the town to hire an outside expert on structural issues and to hire an expert on floodplain issues or flooding issues. Fine. They said to us, and their decision just says, because the code requires 2 loading docks. No logic, no explanation, no rationale. But they say because the code requires 2 loading docks, either put in 2 loading docks or go to the Board of Adjustment and get a variance. That's what they said. Building inspector didn't read the code that way. We didn't read the code that way. He issued a ruling, nobody appealed it. So our choice was what? I mean, if we're coming to you and saying, look what the board, the Planning Commission said, we need a variance because they think 2 loading docks are required. You are, in my view, the final arbiter of the meaning of the zoning code. Delaware law, Title 22, says that. And so we're coming to you now saying, look what the Planning Commission said. It said we have to have 2 loading docks, even though they never bothered to challenge or appeal the decision of the building inspector in a timely manner. So give them a variance. Well, I think it's perfectly reasonable and fair for this board to say, that's not what the code says. Appreciate that you sent it to us, appreciate that you gave us a chance to weigh in. But when the code says a commercial real estate establishment, singular, exceeding 15,000 square feet, it means that it has to be one establishment that exceeds that amount, not a series of small stores. That's what the code means. There is no need for us to grant a variance because no variance is required. You have the right to say that when presented with the question. And we have no choice but really to come to you, right? And say, because they directed us, they said either put in 2 loading docks or go to the board. We're not putting in 2 loading docks, it's a waste, and it creates a whole host of other issues. But we followed their instructions. But now you're asking the question, well, what do we do here? Because the Belhaven folks say that their plan complies, the Planning Commission says it doesn't. You're the ones who ultimately have the interpretive authority. It would be illogical, and you can see the headaches, and I had headaches after reading the notice of decision. Who's in charge? The building inspector issued a written decision. We followed it. We relied on it. The planning commission has said something else. If we had disagreed with the building inspector or the planning commission had disagreed with the building inspector, we're supposed to come to you and say, figure this out, who's right. But now the planning commission says, we can just ignore the building inspector and tell you what we think the code means instead, and you're stuck with that. And by the way, this board is apparently, according to the planning commission, stuck with that. That's not right. That's not the role of this board. So that's why we came to you, planning commission told us to, but that's why we said to you, we think we had it right all along. There's no need to grant a variance here. It's not necessary. And the building inspector agreed with us. And I think that this board, in response to that request, can say, you're right, Bellhaven. You don't need a variance here because your original plan is the plan that complied with the code. You are perfectly and totally within your power and right to say that. Otherwise, I don't know what to do as a property owner. Who do I rely on? I meet with the building inspector. He tells us what the code means. I spent a lot of money preparing plans. Nobody challenges the building inspector. And then over a year later, 13 months later, the planning commission announces a different view and says its view controls after all. Everything ultimately about the zoning code flows to this body. And so you have the final interpretive power. If you agree with us that no variance is necessary, then I don't think we need to do anything more. I think that's all you need to say. If you do think a variance is necessary, then we'll demonstrate to you why we think there's exceptional practical difficulty and why that doesn't make sense. But we don't have to go there because that's not what the code requires.
Now, our jurisdiction is simply, coming back, is the interpretation of that code, and do we agree with the building inspector? To sum up what you were saying, we have no jurisdiction over the planning commission. Don't understand why they said use the word variance, but we adhere to the building inspector's report, and then we interpret that code, and that's what we are here to make a decision on the loading dock. Okay. Any other questions?
Well,
Or Fred, go ahead.
oh, well, I don't know if there are more
No,
questions.
I'm
for
not
Mr.
seeing.
Forston.
Oh, I'm seeing no one else wanting.
Okay, so I think
Hang on.
I think Mr. Forston might also say that if there are two reasonable, and he did say, if there are two reasonable interpretations, then the one favoring the property owner, given the rules of statutory construction, are to be taken into consideration at the very least. I think we should hear from Mr. Burns, and I did not mean to cut you off.
No, I understood. Mr. Forson, you in your papers say that the Planning Commission should have taken an appeal or an objection from the building inspector's decision, our report of June of 23. Has that ever occurred, that the Planning Commission or any other body here takes an appeal to this board or anybody else in the absence of an actual case there? And you got the building inspector's report, but you seem to put a lot of weight on that, because I do have a whole other line of questions I'm going to raise on this appeal process. So I'd like to understand, you're way more experienced than I am in terms of what happens here, and maybe Fred or Alex could also address whether that sort of process ever occurs.
So let me answer that question. It's two different questions. Let me first answer, has this ever happened before? I don't know. I can't answer with certainty whether it has ever happened before or not. I know in an earlier iteration of this planning commission years ago, when there was another controversial project in town called Ocean Bay Mart, or the Beach Walk project, that there had been certain determinations made by this board, and at the subsequent planning commission, there was talk about whether they should appeal the Board of Adjustment decision to the Superior Court. Ultimately, they did not, but it's certainly not unprecedented for that to occur, and in other jurisdictions, there have been instances where For example, the Newcastle County Board of Adjustment granted variances, and the Newcastle County Department of Land Use then appealed that decision to Superior Court. So it happens. In terms of jurisdiction here, your rules provide and case law provides that anybody aggrieved by a decision of the building inspector has 30 days to come to this board to raise the issue. He issued his decision on June 28th. He says only one loading berth, thank you, is required. So everybody was aware of that. And if they disagreed or thought, no, we want 2 loading docks, then that was the time to raise the issue, not 11 months later. And the Planning Commission is just like anybody else. Any person aggrieved, of course, it's made up of individual residents of the town, but they had standing to pursue it if they wanted. They chose not to. Instead, they announced that essentially they take the view that they don't really care what the building inspector says. They're allowed to trump him, and that's what they did when they issued this condition. Now, the condition itself, to my way of thinking, is somewhat odd. They just unilaterally announce that 2 loading docks are required and say either build 2 loading docks or get a variance from the Board of Adjustment. But as I say, ultimately, final interpretive authority of the zoning code is your all's purview. And if somebody came to you and said, I've got this extra peaked roof, and so I need a variance from the height requirement, but the building inspector said, no, they don't. They don't need, they're within height when you measure it correctly. I think you all would thank those applicants for coming, but good news, you don't need a variance, your plan complies. If someone came to you and said, I need a setback variance because I'm expanding my Florida room and now I need a variance of 2 or 3 feet, and the building inspector came to you and said, they're not measuring it correctly when you apply the way it's supposed to be measured, there's no variance required after all, then I think you all would say, I'm not granting you a variance, you don't need one. And I think that's all we're saying here. Only 1 loading berth is required, and so therefore there's no need for a variance, and that's all you need say on this subject. And we'll get to 2 other issues, the height of an antenna. Well, antennae are exempted from the height requirements of the code explicitly, but they told us to come to you and get a variance for that. So we came to you, because I'm not really sure what other choice we had, but I don't know how you grant a variance for an antenna from the height requirements when there is no height limitation on antenna.
Let's stick to the,
Yeah.
All right, but you see my point. This isn't this issue is going to come up again.
Understood.
Yeah, so that's why we came here, and so we ask for your guidance on the subject. If you agree with the building inspector, if you agree with Belhaven, and as Fred helpfully reminded me and pointed out, the same logic that says if a code, that I cited earlier, if the code provision is ambiguous, and at best it's ambiguous, then you interpret it in the way that favors the property owner. The Planning Commission's statement and requirement is completely silent on that issue, although we cited the case law to them. So I don't know what else to do. I'm told by the Planning Commission I have to have 2 loading berths. Building inspector told us to the contrary. The Planning Commission said get a variance from the board, but if you all read the code as we do and as the building inspector does, there's no variance for you to grant. And so I think, again, a simple declaration that there is no variance to grant because 1 loading berth complies with the code is sufficient.
Okay, thank you. Any other questions?
Yes, because there's court cases with First Street Station. We've talked about this before as a Board of Adjustment on another issue. But they agreed, the court determined that a loading dock was needed even though they were individual stores because they were all in the same building. The second thing I just want to bring up is this whole issue of Planning Commission and their decision-making has been a subject in the city of Rehoboth Beach for the last, several weeks, and an ordinance failed when they tried to take the site plan decision-making away from the Planning Commission. And I'm very, I don't want us to get caught in the middle of, you know, kind of a, not a fist fight, but, you know, an argument between the mayor and the commissioners and the Planning Commission and the building inspector.
So we won't.
It's not our, but, you know, this has already been a public meeting, you know, about who has the final authority. And at this point, the Board of Commissioners is saying the Planning Commission has on-site plan review.
So let me respond briefly, if I may. I want to correct two things about that. First off, there's no court decision about loading berths in the city of Rehoboth. No court decision, okay? If there was, we would have read it. Fred would have read it, I would have read it, Luke would have read it, and we'd be following it. So there's no court decision about loading berths. There is an instance where there's a loading berth for a project, but my understanding is that that was put in at the request of the owner, not because it was required by code. People may disagree with that, that's my understanding. But there's no court decision on that. As to what recently happened at town council, or I'm sorry, the commissioners meeting, there was an ordinance proposed to be introduced that would have made changes to the process, and it was not introduced by a vote of 3-3 with one person not there. That's all that signifies. I'm not disputing that the Planning Commission has the authority over site plan review, but that authority is circumscribed by Delaware law in an important way. And I've cited this case to the Planning Commission. I'll cite it to you so we're all clear about this. It's called it's a Delaware Supreme Court decision, Tony Ashburn v. Kent County Regional Planning Commission. And there, in that case, the Planning Commission rejected a plan, and it rejected a plan based on the very similar language to your all's code. You know, the code talks about the Planning Commission shall look at public safety and look at this and look at that and look at this. And what did the Supreme Court say? The Supreme Court said you can't reject a plan that complies with the code. It said that those provisions, these general welfare provisions about different things, do not support a conclusion that such factors establish grounds to deny a subdivision application that otherwise fully conforms to all applicable zoning and subdivision code provisions. When people purchase land zoned for a specific use, they are entitled to rely on the fact that they can implement that use provided the project complies with all the specific criteria found in ordinances and subject to reasonable conditions which the Planning Commission may impose in order to minimize any adverse impact on nearby landowners and residents. To hold otherwise would subject a purchaser of land zoned for a specific use to the future whim or caprice of the Commission by clothing it with the ability to impose ad hoc requirements on the use of land not specified anywhere in the ordinances. The result would be the imposition of uncertainty on all landowners respecting whether they can safely rely on the permitted uses conferred on their land under the zoning ordinances. Here we have a code, per the building inspector's decision, which went unappealed, only one loading berth is required. And the Planning Commission isn't any more free to reject that interpretation than I am or anyone else because they didn't apply and come to this board for a correction. And so everybody in the city is bound by that determination because it went unchallenged in a timely manner.
And like I said, if we just come back to interpreting the code,
So
that I believe that's the best way forward here in getting this resolved.
that's the substance of it.
Yeah.
I mean, I don't know that we're ready to do that yet, but that's, I think, the substance of what is before us. That First Street Station case, by the way, was a question of not about loading berths, but about whether that was one building or two buildings for purposes of a prohibition against having two alcohol-serving establishments
Right.
in one building. There was an argument made that building constitutes two buildings, and therefore it could have two alcohol-serving establishments in it. And so it's not directly related to this.
But the court overruled that argument, didn't they?
The court, I think,
as
found that
one.
it was one building.
One building, exactly.
Have we answered Bill's question yet? I don't
really.
think we have. I'm still
I guess
waiting
I-
for
I
the
guess I-
answer to Bill's great question.
I guess I'd like to hear, from Alex and also like to hear from the Planning Commission in terms of what it is that they are asking us to do. And then I think we have to decide whether what they're asking us to do is something we feel we have power to do.
And I can say, just quickly in response to your initial question, and that is that I just don't think this happens very often. I mean, in my experience, I don't believe it's happened, that the Planning Commission has disregarded a decision of the building official in this fashion, exactly. So I don't think that questions like this, I don't think there's a lot of history out there for us to dig into to sort our way through this dilemma.
Fred, can I get a clarification from you? Am I correct that the Planning Commission has the right to add additional conditions to a plan approval?
So it does within the bounds of general health, safety, and welfare, and the criteria that are listed, in their jurisdiction. So if they can identify a specific concern, then they can craft or narrowly craft a condition to address that concern, and it all has to be under the rubric of being reasonable. It's got to be a reasonable condition.
That seems to be this case.
Well, no, I don't think so, because the notice of decision doesn't go on and on about the need for two loading docks. It doesn't say that we're not sure whether one or two are required, but we think two are required, and therefore we're going to exercise this authority of ours. That doesn't seem to be what it is. In fact, we're invited and specifically instructed by the Planning Commission that they don't really take a position on whether we grant the variance or not. I mean, they don't seem to have a strong feeling about the necessity of the second one. They just simply say that the code requires it and that you need a variance to move forward.
Yeah, Mark, I don't think that they're going off on health and safety. I think if they wanted to go off on health and safety, they could have done it. That might have been a different issue, but they seem to be going off on their interpretation of the building code.
Which is not their domain.
Well, that's
Right.
the issue.
That's the issue, but they say it's their domain on site
Yeah.
plan review.
Yeah,
So-
and that's
so
why
then
I
that
think
is
it
a
would be useful to hear
controversial
from
issue
their
right now.
lawyer
time.
about
Okay,
what it
so
is
let's-
that
yeah.
they're-
Over each other.
Thank you, Ann.
All right.
Agree. Bill, any additional questions? Jan?
No, is he going to have?
Well, I want to go through everyone.
We're going to hear from
Yeah. I wanna
Okay,
go-
that's
then
what I
wanna go
wanted
to
to say.
Alex.
Yeah.
Other
And
questions?
Luke
Not
also.
for the applicant.
Okay.
And
All right.
probably not for Matt either, but I hold that off.
Thank you very much.
Thanks, Alex.
It's days like today where I'm reminded this is a very difficult job and, sometimes thankless. But I think to answer the question first about the appeals, state code breathes life into the BOA. And if you look at section 324, appeals to board, it states that appeals to the Board of Adjustment may be taken by any person aggrieved or by any officer, department, board, or bureau of the municipality affected by any decision. So there's some things to think about there. Is the Planning Commission an officer, department, board, or bureau of the municipality? Is the Planning Commission affected by a decision? That's what you'd be thinking about for an appeal.
Yeah, but Alex, I saw that, it's actually in the city code too.
That's correct. Yep, it's essentially the same.
270-71.
270-71, yep.
And they're not taking an appeal though.
Right.
Because there is a process, which is what I was going to focus on. There is a process, because I think that the Planning Commission may well be a board or a bureau of the city. There's a process for filing a notice of appeal. And the Planning Commission has not done that. And so I'm bothered by the fact that there is a process. You're supposed to file it within a certain number of days. You're supposed to file papers saying it's an appeal. And they haven't done that. So that's why I'm asking, when we get the Planning Commission lawyer here, why are you here doing that rather than taking an appeal of the decision of the building inspector? Now, the Papa John lawyer may say that that's too late to do it, but to me, at least, that would have been the right process under 270-71, rather than throwing in a piece of paper that says, this is what we think, but not actually doing it as an appeal.
Right. And I also just wanted to add that under the state codes, the powers of the Board of Adjustment may be helpful in wrestling with these questions. If I can find that.
That's in 270-74.
He's
the
looking
city
for,
code.
he's looking for the
The
state.
state code is, the state code is arguably broader
Than
than,
the city code, but aren't we limited by the city code?
well, we're authorized by the state code, and it becomes questionable whether the city through ordinances can restrict our jurisdiction. There's a line of cases, the NEPA case, but I don't feel like I'm capable of speaking to that today.
So what is the state code? Did you find the provision?
Yep, so this is state code, this is Title 22, Chapter 3, and it lays out determinations of the board. So that's Section 327, and it's essentially, it's similar to in the zoning code, Article 8, that's 270-74, and that lays out the powers of the Board of Adjustment. So you might want to consider those factors in determining the jurisdiction of the board. I think at the end of the day, Matt just wants to get it right. The building licensing's interest is in getting to the right answer, right? And so if there's 57 municipalities in Delaware, I'm sure all the building inspectors want to get it right and think they've gotten it right.
Contrary to popular belief, yes, I do want to get it right.
And so, you know, that's the interest of the building licensing department. And there is an appeal procedure for any determinations Matt makes. You know, we certainly support the idea of appealing any of his decisions. But, you know, I think the elephant in the room is the pending or potential litigation, the threat of those issues, because under the Freedom of Information Act, when an administrative land use decision is appealed, that litigation exception is triggered. So when there's an appeal from the Planning Commission to the commissioners, there's arguably litigation. And to that end, I'm trying to be very careful. I'm trying to be helpful, but also I don't think I'm authorized to disclose all the confidential communications I've had. So, you know, to the extent I can be helpful, I'm happy to. But, you know, this we're here today. It's not an appeal of Matt's decision.
Correct.
It's not a classic variance in the sense that Matt says there needs to be a variance. So we're trying to navigate the procedural posture as best we can.
Understood.
Could I dive in for a sec? Or did you?
No, I was going to say, questions for Alex?
No, I don't have a question.
Okay.
Per se. Excuse me. Go ahead.
Okay, so is the board ready to close down?
Well, I thought he
No, I
wanted
want
to
to hear,
stay here.
don't we hear from the planning commission?
Yeah, you're
Well,
right.
he's going to come up as commentary. I'm going to call him first under public commentary, unless you want to just,
Well, I think he would like to speak.
so you're next anyway, so, and we're not going to put the 5-minute
When I say you
limit
for
on.
the record, I mean Luke Mehta.
Thank you. And with your permission, may I speak? May I speak? on
Certainly,
the
Luke.
podium? I've got some papers.
Of
Yes,
course.
thank you.
Yep.
It might take me more than 5 minutes if that's.
I was going to say, well, I'm not going to start the timer.
Thank you. So with all, I'm happy to answer any questions, but I do have some observations based on what I've heard so far. In some respect, despite all, we've been going at it for a while, in my view, it is incredibly simple. To the extent the applicant is seeking a variance from this body, the Planning Commission has no position. It is not our job. That's your job to grant variances. With regard to Mr. Forson's question, oh gee, well, what is my recourse if I disagree with the Planning Commission's interpretation of the code? Appeal to the Board of Commissioners, which is what they've done. That entity is the final arbiter of the code and the zoning code to the extent it's not in your jurisdiction. And this matter, in my view, is not before this particular matter, unless they expressly seek a variance, is not appropriately before you. There is no appeal. They've conceded there's no appeal from the Planning Commission to you. And there is no appeal from the building inspector to you. If you read the language, and I'll read it to you. Under 270-74, you have jurisdiction for three things: Special exception, that's not what's going on here. Variance, I don't know whether Rich is asking for a variance or not. If he's asking for a variance, go forward with the variance. We have no position. That's not our job. And what about appeal? They're not appealing from the Planning Commission, and your code is very specific. The Board of Adjustment shall have the following powers: to hear and decide appeals where there is alleged to be an error in a decision of the building inspector. They are agreeing with the building inspector. You have no jurisdiction on this particular matter. Their recourse, which they've already availed themselves of, is to go to the Board of Commissioners. Plain and simple. We could talk about this till the kingdom come, but it's very, very simple in my view. Now, I'm happy to go into more detail. There has been discussion about whether, and I don't think, by the way, the Board of Adjustment has any power to issue advisory opinions or declaratory judgments. Like, that's not in your code. And your power is derived from the code, the state code and the city code, just like the Planning Commission's power is derived from the code. Plain and simple. I strongly disagree with the notion that the Planning Commission could have and should have appealed as an affected party the decision of the building inspector. The Planning Commission is a quasi-judicial body, just like you are, sort of acting in public as a quasi-judicial body. The notion that the Planning Commission could have, should have, before voting in public, in open session, given their reason, say, wait a minute, we're going to preempt that process, we're going to jump and we disagree, then Rich, rightly so, would be all over the Planning Commission for prejudging the outcome. The Planning Commission, as a quasi-judicial body, is not an affected party, under the I submit, under the meaning of the code, to appeal a decision of the Planning Commission, just like you are not an affected party to appeal a decision that you disagree with. You act, you decide in public, consistent with due process. There was some discussion that the Planning Commission just, summarily decided that 2 loading berths. I'm not going to get it. I am just going to set the record clear, though. The notice of decision speaks for itself. There was a lengthy discussion, whether you agree with it or not, about the code interpretation. So it was not willy-nilly arbitrary. There was a detailed analysis in the NOD regarding whether 1 or 2 loading berths was required. And unless they ask for a variance, that issue will be decided by the Board of Commissioners. With all due respect to Matt, on that loading berth issue, and again, I'm not going to re-argue, I'm just setting the record straight. Again, I invite you to actually read the NOD, which is why I attached it to our amicus statement. And with all due respect, I think the record is clear and the NOD sets forth that Matt backed away from that decision, both factually and legally. So long story short, to the commissioner on the right, I do not believe on this particular issue you have any jurisdiction at all unless they ask for a variance, which I'm still not sure I've heard them do. With regard to the issue whether the Planning Commission, which I think is a really significant issue, whether the Planning Commission could or should have appealed the decision of the building inspector, I respectfully submit that is a decision that the Board of Commissioners ought to make, not you. They are the ones who decide which government bodies have what power. Your jurisdiction is much more limited and restricted, in my view. I agree you do not have advisory opinion authority. I agree you do not have declaratory judgment authority. Again, I'm just in terms of the record, I'm not advocating with regard to variances. Mr. Burns pointed out the definition of loading berth for in the code. If you get to that issue for your variance, I just encourage you to read the entire definition of loading berth, which also talks about adequate maneuverability.
Can I ask a question?
Please do.
Could the planning commission have just decided that it was not going to abide by this board's earlier decision to increase the FAR to 3.0?
No, to the contrary, I think the planning
No,
commission
I'm asking, do you
very,
think
very
they had
clear.
the legal authority to do that?
I think if the Board of Adjustment grants a variance on a matter that was properly before the jurisdiction of the Board of Adjustment, then of course the Planning Commission would abide by that.
And then why is it planning commission free to ignore a decision of the building inspector?
Because the code expressly confers.
Where's that?
So if you look in 270-30E, I believe it is, and again, with all due respect, I think this is an issue for the Board of Commissioners, but happy to engage into it. The Board of Commissioners has expressly, and this has been in fact the practice, so I disagree to the extent somebody suggested otherwise. The practice of the Planning Commission has been to, over the past 20 years, has been in fact to disagree at times, where appropriate, with the decisions, well, they're not even decisions, they're preliminary determinations by the building inspector. But in 270-30E, or maybe it's, I don't have it in front of me, it's in 270-30, the Board of Commissioners expressly empowers the Planning Commission to review zoning codes, to review site plans in view of the zoning code and Chapter 236 and other applicable federal and state law that may be applicable.
Does that mean that the planning commission gets to interpret the zoning code?
That's what I wanted to understand. In view of.
That is my interpretation. That's been the practice of the zoning code, practice of the Planning
I don't
Commission.
understand then why there are appeals to this body about decisions of the building inspector. I'm really struggling to understand your
Well, yeah, well,
argument.
so not all matters go to the Planning Commission. There are plenty of matters that do not go to the Planning Commission
Sure,
that
but
would
this is
benefit
about
from an appeal.
interpretation of the zoning code.
I'm sorry?
This is about the interpretation of the zoning.
Yes, and there are plenty zoning code determinations that the building inspector makes that don't go to the Planning Commission. The Planning Commission only receives large plans, not everyday plans regarding the zoning code. So to the extent the building inspector is making a zoning code decision on a matter that does not go to the Planning Commission, then of course there should be an avenue for appealing that to the Board of Adjustment. On matters that are large enough to go to the Planning Commission, the Board of Commissioners, whether you agree with it or not, currently, and they may be changing that, they may be diminishing that power, they may not be. They tried to last week. But right now, and certainly the practice has been that the Board of Commissioners, when it does have a site plan before it, does have the authority to interpret the zoning code. And if it's not like we just disregarded it. The Planning Commission listened to Matt and respectfully disagreed with him, especially, again, on this particular issue, if you listen to the record and the decision, where, with all due respect, Matt walked back his determination on zoning, on the loading berth number. So that is my view, and I think it's consistent with the practice, but ultimately, that is a decision for the Board of Commissioners to resolve.
Go ahead.
No, I guess, you know, from the very beginning, when we got this first request, I've just been uncomfortable because the appeals from the Planning Commission are to the Board of Commissioners and not to the Board of Adjustment. And so it wasn't the same as Mr. Forston coming in and filing a variance request. It was complicated, and you know, it just wasn't how, it was difficult, frankly, because the decision, the appeal to the Planning Commission had already been filed. And I've been in Rehoboth a long time, and on site plan review, the appeals are always to the Planning Commission. I mean, always to the Board of Adjustment. I'm sorry, always, the Planning Commission always appeals to the Board of Commissioners and not to the Board of Adjustment. If the Planning Commission says to an applicant, you know, Mr. Papajohn, you know, we're unsure about your steeple, antenna. We think you should get a variance, you should go to the Board of Adjustment. Usually, in my experience, the Planning Commission is very specific and says, you know, you need to get a variance for this. And that's, it just seems to me that this has been unduly complicated for things like, you know, a fence, a gate, whatever you call it, and an antenna, and the 4.0 or the 3.0. But this is,
Yeah. So,
yeah.
yeah.
I'm
But
just,
again, let's get back to the applicant filed for clarification for our interpretation. I don't think we go beyond that. We don't give opinion on that. We just stay in, you know, we look as the building inspector's report as what we have to agree or disagree with Matt's interpretation of the code.
May I interject? I think there's a really important clarification. I think we have to be really careful. There's a lot of sort of sweeping general statements. I always like to take it back to the code and actually look at the language of the code. And I want to
We would
make sure
agree.
we're very clear here. I think it was entirely appropriate, and this is why the Planning Commission made this a condition, for you to clarify one of your prior decisions, basically like a motion for reconsideration, the one that you just voted on. No problem. In my view, that's very different than the Board of Adjustment actually issuing an advisory opinion or declaratory judgment on a matter that, in my view, is not properly before you. You do not have jurisdiction. There is no variance being requested, and there is no proper appeal from a decision of the building inspector on this issue, and they have another remedy that they've already availed themselves of, which is appeal to the Board of Commissioners.
Mr. Mehta, we wouldn't be here today, would we, if the Planning Commission just denied the application, saying that you're proposing one loading berth and you need two?
I don't know, Mr. Townsend. I mean, the Planning Commission isn't directing you guys to do anything. We conditionally approved a site plan, and it's really up to the applicant. The applicant has chosen to go to the Board of Commissioners and to you. So I can't answer that question.
The Planning Commission has invited the applicant to come to the Board of Adjustment.
To be sure.
But had the Planning Commission just simply said, this plan doesn't meet the code, and therefore we can't approve it, then would we be in the same place? Or?
I don't know. You would have to ask Mr. Forson that.
So, and additionally, are you at all bothered by the concept, and I think your answer is going to be no, that the commissioners would be authorized to interpret the code when, to my knowledge, they are not the final authority on the code? And if the commissioners were to find in your favor or find on appeal in the favor of the applicant, would someone then be able to appeal that decision to the Board of Adjustment if it involves an interpretation of the code, which is, I believe, you know, our jurisdiction, our authority?
So here, I appreciate the question, but here again, I think we need to be very, very careful in the language that we are using. If a matter is properly before you, that is, there's a decision of the building inspector that an applicant disagrees with, which is not the case here, disagrees with and appeals, you all make your decision, and then that does not go to the Board of Commissioners. If anybody has a problem with that, they appeal to the Superior Court. On issues that are not properly before you, that is, if there's a decision of the Planning Commission that somebody disagrees with, they appeal to the Board of Commissioners. And to the extent there's been a zoning code interpretation by the Planning Commission that it gets appealed to the Board of Commissioners, then I think the Board of Commissioners would render a decision about what it thought. It's the drafter of the code. What it thought the zoning code meant. Let me finish. That decision could be appealed to the Superior Court, and I think you will find support for that in the Packham decision from a very esteemed former Vice Chancellor, Chandler, who said quite clearly that the Board of Commissioners is the one who enacts the code. With all due respect to you, you grant variances from the code, but you don't enact the code. And the Vice Chancellor said, I'm not going to give great weight to the building inspector. It wasn't Matt, but it was Rehoboth Beach. And because he didn't write, or she didn't write, the code. The people who wrote the code is the Board of Commissioners. I'm interested in what they think regarding the intent. So with all due respect, I think if a matter is properly before the Board of Adjustment, then yes, you render your decision, and appeals go to Superior Court. If it's not properly before you, somebody's appealing the Planning Commission, it goes to the Board of Commissioners, which they've done here.
Do you know what might happen if, procedurally, if this board were to uphold or issue a declaration that no variances are needed, for instance, for any of these clarification?
I'm not going to speculate. All sorts of things could happen. Your decisions are appealable to Superior Court.
You're also contending that simply in our application today, let's take the variance away from it, that the applicant was not allowed to ask for clarification.
No, so again, no. Clarification of your prior decision, I think that was appropriate. But
On the FAR.
on the FAR.
Okay.
But an advisory opinion or a declaratory judgment, when they agree with the building inspector, there is nothing in the code that supports your jurisdiction.
So they are not allowed to ask for clarification for this board's understanding, interpretation of the loading docks and the height issues.
I do not, unless they ask for a variance, I do not believe the state or city code gives you the jurisdiction to issue an advisory opinion or a declaratory judgment to basically affirm as opposed to reverse a decision.
I'm hung up on the word advisory position. I thought we were asking for, the application was asking for an interpretation of this board on those specific codes.
Well, regardless of how they put it, unless they're asking for a variance, however they're putting it does not confer jurisdiction on you. They can do it a million different ways. Unless they use appeal of his decision, variance or special exception, your job is over. We could have been home by now. May I just address a few other things before I sit down? There's reference to whether the Planning Commission has ever appealed a decision of the building inspector. I'm not aware of. Mr. Forstner refers to other jurisdictions. We're not other jurisdictions. That's the whole point. We're looking at the Rehoboth code, not anybody else's code. With regard to the case law that Mr. Forstner refers to, the Eastlake case, it begs the question, folks. It begs the question. The Planning Commission's view is that the Board of Commissioners has specifically conferred upon it not only the power, but the duty to review a site plan in view of the zoning code. So it begs the question, who gets to decide? That's the whole point. Who gets to decide zoning code compliance? The other red herring is the issue of if a statutory provision is reasonably susceptible. He didn't really articulate it quite well. It's not as simple as he makes it out to be. It's a basic provision of Delaware statutory interpretation, which is if a code is unambiguous, you apply the code. What the Delaware case law says is if a code provision is reasonably susceptible to two competing interpretations and you are in the context of a zoning code, then tie goes to the property owner. And again, the Planning Commission, if you get to that issue, and in the context of a variance, Planning Commission is not going to take a position on it, but we do set out in detail in the notice of decision why the Planning Commission respectfully disagreed with the building inspector. So for the time being, I think I've answered the questions and addressed the comments I've heard up to this point, but I'm happy to stick around and answer other questions you have.
Thank you. So we are in public commentary, so we're going to...
Mr. Chair, can I just briefly respond?
Yes.
I want to
Yes,
make
Mr.
sure the
Forstner.
record is clear on a couple of things. I mean, at one point early on, Luke said something I wholeheartedly agree with, which is first principles, what do codes and things say? And the question came up about state law, which trumps local law, as you can imagine, just like federal law trumps state law trumps local law. And in fact, Delaware law is clear that municipalities and counties can only exercise their zoning authority as permitted by the General Assembly, because the General Assembly delegates zoning authority to local jurisdictions. And Alex read, but I want to read it again because I think it's important, because it seems as though Mr. Mehta disagreed. Appeals to the Board of Adjustment may be taken by any person aggrieved or by any officer, department, board, or bureau of the municipality affected by the decision of the administrative officer. So clearly the Planning Commission is a bureau or board, and it, under state law, if it disagreed, I'm sorry, I'm holding up my phone because I didn't bring this particular provision of the Title 22 with me, but state law requires that if they didn't like the decision, they had to bring it to you, because all roads on zoning matters lead to this board. All roads led to Rome. All roads on zoning code interpretation lead to this board. And that's what that section of the code says. When the General Assembly was setting up the rules for every municipality, they authorized municipalities, they authorized counties to create zoning codes, and then they said if anybody's got, and they said the building inspector is the interpreter of the code or the administrator of the code, and if you disagreed with something he did, you go to a Board of Adjustment. Board of Adjustment also exists to grant variances and do some other things, but that was the important part of this code. And why was it? Because the General Assembly didn't want to create the situation which the Planning Commission suggests should exist, and that is there's multiple people who can tell you what the zoning code means, and depending on who says what, you go here, you go there. If a person is aggrieved by a Board of Adjustment decision, and that happened with respect to the first variance you granted, somebody appealed that to Superior Court because they disagreed with it, the Superior Court affirmed. But if somebody disagrees with a decision of the Board of Adjustment, Delaware law provides you go to Superior Court, and there is a set standard of review, and it's fairly specific. The decision has to be supported by substantial evidence. It can't be contrary to law. There's some other things. There is no right of appeal to the Superior Court from a decision of the city commissioners. There is a more limited review, it's called writ of certiorari, not as robust as the right of review that the General Assembly created for reviews of your decisions. And so one of the perhaps unintended consequences, but perhaps intended, of the Planning Commission's decision, they're saying to you, oh, well, if they don't like our interpretation of the zoning code, they have to go to the city commissioners. And if we don't like that, or they don't like that, or somebody doesn't like it, you can appeal to the Superior Court, but you don't get the full review that you get from a decision of this board. So it just doesn't make sense to suggest that the Planning Commission has interpretive authority of the zoning code. And let's look at section, just so we're clear, it's 236-30. I think Mr. Mehta at times said 270, but 236-30E says, the Planning Commission shall determine the content of any applications and associated materials, blah, blah, blah. Then it goes on to say, the site plan shall be reviewed in view of the City of Rehoboth Beach's Comprehensive Development Plan, Chapter 270, which is zoning, this chapter, and other applicable federal, state, county, and city laws and regulations. Now, that's all it says, that you look at the plan in light of what these code regulations require, including federal law. Under the Planning Commission's view, which was just espoused to you, they have the ability and authority to not only interpret the zoning code, but everything else in that list, including state law and federal regulations. They get to interpret all of it in reaching their decision. And I would submit to you that's not correct. If there is a binding Third Circuit decision that says this is what this provision of the federal code means, if there, the Supreme Court recently issued a decision about wetlands. It is binding in this country. And the fact that the Planning Commission is to review plans in light of all federal, state, local laws doesn't mean that the Planning Commission can ignore these other decisions, just like it means it can't ignore the decision of the building inspector which it did not timely challenge. So I wanted to just make sure that we were clear on what both state law requires. They had the right to appeal to this board. They chose not to follow it for whatever reason. And the actual language in 236-30E does not say at all that they have the right to interpret anything. It just says they'll review a plan, but where they're told what the code means, they're not free to ignore that, and that's what the building inspector did in June of 2023. So I just wanted to be clear on that point.
Thank you. So in my mind, I'm a if-then-else thinker here,
Yep, yep.
So Mr. Mehta is saying we do not have, it's not our jurisdiction, as his words are, to give an advisory position. My words were interpretation of the code. Saying we shouldn't even be here talking about that. We shouldn't talk about that. In the event it does come back for a variance, we should not be speaking to that. Your point, but you said, well, they had the chance to say, wait a minute, we disagree. And, so, and they are going, and the applicant is going to the commissioners. But yet, and now this is where the if-then-else becomes circular, the commissioners do not interpret code, Rehoboth Beach commissioners. We interpret code. So if it goes to this appeal, the commissioners may, I'm soon watching this, and would be very interested in our interpretation of code. I don't know if that's legal or not, but they may be interested in this board's interpretation of code. They may make a decision to say, well, we agree they missed the opportunity, therefore building inspector's rule stands. Or they may say, yeah, we think a variance is needed, which we would then be back here at the next opportunity. And, I don't know whether us speaking on that now would hurt us in a future variance. So I'm kind of like stuck in this loop here.
Right. I mentioned at the outset that I had a headache when I first read the notice of decision. I appreciate that you have a headache, and I'm sure everyone in this room probably has a headache.
I don't have a headache yet. It's just I'm just trying to think.
But let me see if I can really address why we did what we did. We had to file a timely appeal with the commissioners to preserve our rights. But I said to the attorney for the commissioners, it's going to take a long time because, we're going to have to write something, and then presumably the planning commission's going to write something, and then we're going to have to write something more, and then we're going to have argument, and months and months. Mm-hmm. And as everyone here can appreciate, time is money. And this project's already been held up a number of years. We're going to talk about that more in a little bit, and costs have only gone up, up, up. So my goal as the attorney for the project, Hal Duke's role as attorney for the project, our goal here is to try to get to the project as quickly as possible. And I said to the commissioner's attorney, look, the board the planning commission invited us to go to the board to seek a variance. But we all know that if someone comes to the board seeking a variance and the board says, you don't need a variance, that's what the board is going to say, right? The board doesn't deny a request for a variance if no variance is needed, because that would imply that you couldn't do what you're seeking to do. The board doesn't grant a variance when something's permitted already by the code, because that would be a pointless thing to do, and the law says that boards and commissions don't do pointless things. So we agreed, and we entered into a stay with the city commissioners that we would come to this board and say to you, hey, the planning commission instructed us to get a variance. That's not how the building inspector read the code. That's not how we read the code. Nobody challenged his decision on a timely basis. Do you agree with us that no variance is required? And I think it is totally within your power, totally within your right to say, Mr. Building Inspector, Belhaven representatives, you're right, only one loading berth, and again, thank you, is required. And if you say that, and just previewing a little bit, but if you also say that with respect to the height of the antenna, and you say that with respect to the safety railings, then I think our appeal to the commissioners essentially goes away, because we will have resolved the critical issues. Some of the other things that the Planning Commission said, as I said in my first letter, we'll just forego the solar panels, right? I mean, we thought they were a nice touch. We're not going to, I mean, no good deed goes unpunished. Some of the other things the Planning Commission said, you know, make sure you comply with all federal law, state law. We think that was implied anyway. So we're not appealing things like that. These are the things that gave us pause, and it just seemed to both myself, to Hal, to the attorneys for the city commissioners, that if we came to you and you agreed that, hey, all roads lead to us on zoning, as I said, and we agree that there's no need for a variance because your plan complies, then you're done. And maybe part of that, you can recite the fact that the Planning Commission didn't timely appeal the way it should have, the way Title 22, Section 324 says, any person, including any board, bureau, et cetera, appeals. They didn't do that. So it became, at least with respect to the issue of the loading berth, it became final and binding. And there is nothing inappropriate at all about this board declaring that to be the case. Because if we had actually were asking you for a variance right now, you would still have to ask yourself, do they even need a variance? Right? I mean, you're always asking yourself that question when somebody comes to you asking for a variance. Normally, the answer is yes, because the building inspector's already, you know, looked at the code and said to the applicant, hey, you need a variance for this. In this case, that's not what happened, but if someone else disagreed with that, and they were on notice of it 13 months ago now, no, more than 13 months, 15 months ago now, and they sat by and did nothing, they can't then sandbag and wait 13 months and then say, well, you have to do this anyway, even though we didn't appeal his decision.
Okay.
Thank you.
All right, thank you. Yeah, I do want to move to the public commentary. Cindy, come on up.
Is it on? Is the mic on? Cindy Lovett, 4 Canal Street.
You want to lower it for
Okay,
you?
Cindy Lovett.
There you go.
There we go. I'm not that short. Okay, Cindy Lovett, 4 Canal Street, Rehoboth Beach, 19971.
Ms. Lovett, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the
I
truth?
sure do. Okay, this has been a lot. Okay, I have a question I'd like to ask Matt. Do I ask it through you or do I ask Matt?
So this is your opportunity to give testimony.
Give testimony.
I'm sorry. So if let's say you have a question you think we should be asking, I guess the board will be the judge of that.
Okay.
So tell us why we should ask Matt a particular
Okay.
question.
I would like to know, as a citizen, full-time resident who walks this town all the time and sees the little businesses up in the area where the hotel will be, get a couple of boxes chucked out in front of their store, you know, a couple times a week. I'd like to know what, as this person, does a second berth get me? How's that going to help me as a citizen? Why do we need the second berth? That's my first question.
You want us to?
Well,
Can you
Ask that, or
answer?
you want-
Is there an answer?
Let her
Yes,
go through all?
please. Is
Okay.
there an answer?
No, go. You can finish, and
Okay.
we'll go to.
If I understand this, and I'm not an attorney, I'm not any of this, I've just been listening to this as an interested party. It sounds as if there is nothing to seek a variance from because this decision could actually go either way on whether the second dock is needed. It sounds as if we could we could say, yes, we need to, or no, we don't. So in baseball, the tie goes to the runner. In this case, I don't understand why the Planning Commission has sent this to you guys to make no, that's not true. That's what I understood.
The Planning Commission did not send it to us.
Okay, so you guys got involved in this. So I think if there is no need for a second loading dock, let's take the logical way and let the property owner be the, the one to bend or whatever, make the decision to go that way. And I'm asking you, please don't send this back to the mayor and commissioners. Please, I hope we can make a final decision here on this. So, and if there's an answer to my first question, I'd like to hear it. What does the second loading dock get me?
Right.
Me.
I did ask Matt an earlier question today. Are delivery trucks required to use a loading zone? I believe the answer is no. Wilmington Avenue and Rehoboth Avenue have codes that allow deliveries,
Right.
park for 20 minutes, drop a box off.
Yep.
So I would imagine that would still be, is that correct, Matt?
That's correct.
Yeah.
Okay, so I don't understand the logic tells me, my logic tells me, we just don't need a second berth. So since it's not required in the code and it can be read either way, in my mind, then I don't even know why we're even thinking about a second berth. That's it.
Thank you.
Okay, thank you.
Paul, did you want to come up? No, do it.
All right, let's line up by height before we continue.
I'm Paul Lovett. I'm also from 4 Canal Street. And
Mr. Levitt, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I just have a message, and it is that I think this applicant here has been incredibly patient and incredibly persistent with the city. And I see a city that looks as if we've got 6 or 8 attorneys, or probably more, debating about who has the authority. Who has the authority to do this? And we look at all of these people that have, all of you on your committee, and the city commissioners and the planning commissioners, who are incredibly volunteering your time to do this. But as a city, I don't think we're looking very good, because we have people here who grew up in that building that you see right there. And they happen to still own the property, and they're willing to invest $80 or $100 million, and the number is growing and growing, in improving this location, which is at the very heart of the city. And I think we need to figure out how to do this better. That's my message.
Thank you. And
Gentlemen,
who had their hand up?
Dr. Trejo.
Oh, Dr. Okay, Dr. Trejo.
Constantly.
Yeah, when they start. After the swearing in.
Okay, so hold on.
Hold on, wait, hold on.
Carol, where are you going to go over here
she
first?
goes.
We're going to Dr. Trejo.
Let her go first. Let her go
Okay.
first. Go ahead. Go ahead. No, please, go ahead.
Carol Everhart, Rehoboth Beach, Dewey Beach Chamber of Commerce. We've been a long
Ms.
supporter
Ms.
of the-
Everhart, do you solemnly swear the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. The Chamber's been a supporter of this project from the very beginning. We worked with the Planning Commission, with the comprehensive plan. We were in complete agreement. We continue to support it. I'm not an attorney, but I've heard 2 things that really struck home. One was, when I don't know what to do, I go to the front line. Your front line is Mr. Janis. That's number 1. They'll tell you what to do. They'll tell you if it's right. The other thing I've heard is that this project is, in the end, goes back to the property owner, right? The law says the property owner is where it would go. So we continue to support it. We think it's a wonderful project. It's exactly what you said you wanted. You wanted today's amenities and yesterday's charms, and that's what this project is. Thank you.
Thank you. Anyone else? I think Woody, you had your hand up before. Yeah. I'm sorry. Wait.
That's
Wait.
okay.
Wait. My mistake.
That's
Sorry, guys.
Mr. Chairman, I don't mind going last.
I don't know.
I don't mind going last. I have no problem with that.
Gentlemen, I'm sorry. Did you wish to speak back there? Yes. So I guess we'd like to hear from you now. Mr. Trejos wants the last word. All right. So I think we've got Mr. Trejos at the mic. So, or Dr. Trejos. Could you introduce yourself, sir?
Yes, I'm Dr. Michael Trejos, co-owner of the properties at 7 through 15 South Boardwalk and 1 Wilmington Avenue.
And sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I was going to make comments with regard to the merit of having 2 loading docks, but clearly this discussion has evolved into jurisdictional and code interpretations. So I will hold off making any comments with regard to merit until such time as the jurisdictional and code interpretations go through, and then I can make further comments on that. But with regard to now jurisdictional, I do not take a position on that. That is up to the attorneys for the Planning Commission. But I do want to address one thing about code interpretation. As I mentioned, I'm co-owners of the properties located at 7 through 15 South Boardwalk and Wilmington Avenue. That includes Gus and Gus, the 5 and 10. Y'all got to know that, Starkey's and Zoggs and all that type of thing. Those 2 properties currently I co-own are co-owned as separate LLCs. Independently, those properties are under 15,000 square feet. But if I was to acquire additional properties and then combine them, guess what? They go above 15,000 square feet. As such, as my properties on the boardwalk are a single, I own them as a single corporate entity. Regardless of how many establishments I have in there, they're a single corporate entity and they're under 15,000. Let's now go to a moment to where we talked about one street station. Yes, all of those are independent properties, independent businesses, but the entirety of the properties, from what I understand, is one entity and is greater than 15,000 square feet, which in turn required one loading dock. Now let's go to the current Bellhaven Hotel project. Let's not forget that prior to the consolidation of these properties, each and one of these properties was a separate corporate entity. 17, 18 was separate, 2, 4 was separate, 6 was separate, and Rehoboth Avenues 3, 5, 7, and Part 9 were separate corporate entities. Individually, each of those corporate entities had establishments which in totality were less than 15,000 square feet and thus did not require any sort of loading dock. But now with the consolidation of those properties into one entity, one corporation, one corporate establishment entity, you are now exceeding 15,000 square feet. We need to understand that, and that, I believe, is what the basis was when the Planning Commission was looking at this. We're looking at a single permit, one permit for this entire project, one permit for an entirety of one establishment building property. And as one establishment building property with establishment therein exceeding 15,000 square feet, that is the reason that I took from the Planning Commission meetings that 2 loading berths were required. And so I want you all to understand my position in that regard because, again, there was Mr. Townsend, you made a comment with regard to public safety issues. I will make a notation that you may recall I've already submitted as part of the public record here the comments that were submitted in response to the Rossi Group of the Wilmington-Baltimore Area Task Force and what their proposed plans were with regard to further narrowing Wilmington Avenue and the effects that are already in existence with regard to public safety traffic jams of public safety apparatus equipment, let alone tractor-trailer trucks. The other submission I told you is you can see where their tractors are stacked 2, 3 side by side and in line, exceeding way over 120, 150 feet going down Wilmington Avenue. We have to keep in perspective that that has an impact not only on the proposed establishment, but on all the local businesses in the area and having all these trucks blocking their establishments because of the fact that we're only potentially looking at one loading dock. Again, if this expands to further merit, I can make further comments. Thank you.
Thank you. Okay, I want to ask the board, who was next? Is it Woody?
Two more back there.
Couple
At least
people.
Okay.
back there.
Come on up.
I speak from over here, please?
Yeah.
My name is Mark Marderwald. Do you want to swear me in?
Yes, I do. Address, please.
9 James A. Street, Rehoboth Beach.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Okay. To be brief, I won't go over my qualifications, which would exceed 3 minutes, and if I am under a 3-minute limit here. So let me just say that for the last 50 years, I've had a commercial driver's license, a CDL Class A. This CDL Class A permits me to drive vehicles in excess of 26,000 pounds and tow trailers in excess of 10,000 pounds. It entitles me to tow trailers, doubles, and triples. It also allows me to tow trailers that are tanks with liquids in them, hazardous liquids. In addition to these endorsements on this license, there are absolutely no restrictions on this license. I can drive cranes on the road that dwarf trucks. I've driven houses down the road that dwarf trucks. As to the loading zone and a truck using a loading zone on Wilmington Avenue, it's crazy. You don't need a loading zone. You certainly don't need two, but to have two, which would require one truck, when they're gonna back in. When they back in, they can't see the other side. They can only see the driver's side of their truck. So if something else gets in the way, they're gonna back right over it. A loading zone for a hotel is ludicrous. You got people, not goods coming in. The fact that they're providing a loading zone for all the other businesses, you're lucky they're doing that. I wouldn't do it. Thank you very much.
Thank you.
Thank you.
And Mr. Perry?
Don't worry, I'm watching.
Okay. Because this isn't working the way.
Okay.
I guess it's about right. Richard Perry, 46 Pennsylvania Avenue.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. This whole process I find very interesting, not only as it involves the Board of Adjustment, but also the Board of Commissioners and the Planning Commission. I don't know whether the Planning Commission is playing who's on first, who's on second, or who's got the ball now. Seems to me as though they have put the Board of Adjustment in a very difficult position. But I think we have to accept the fact that the Board of Adjustment does in fact have the final say and interpretive power of our code. Now, what has started to happen here is that the Planning Commission has, in this recent time period, asserted that they have the authority to override the building inspector, to ignore his determination of compliance, and that they are the final determiners and interpreters of the code. I was chair of the Planning Commission, and I certainly don't remember that I had that authority as a planning commissioner. And I also want to clarify that when something goes on appeal to the Board of Commissioners, it is an appeal of a decision based on the record. To say that the commissioners are then in the position of interpreting the provisions they adopted is like saying that if you need an interpretation of a federal statute, that your appeal is to Congress rather than the federal courts. So let's be clear of what makes common sense, which should override everything in interpreting all of these codes and all of the powers that the individual bodies have. This whole thing has, Jan and I were on the Planning Commission together when this application first came before us. And I have watched these people.
No, actually, I wasn't.
Oh, you weren't?
No,
Well,
I
thought
had
you were.
already left.
Oh,
But thank you
okay.
anyway.
Well,
thank
anyways.
you anyway for.
All right, well, my mistake. I thought you were there. In any event, these poor people have been run ragged for all these years, and it's time to put a stop to it. Someone has to make a final determination as to what the code means, and I believe that is your decision. The Planning Commission members, twisted themselves into pretzels, quite frankly, trying to come up with the interpretation that 2 berths were required and not just 1. I pointed out to the Planning Commission that the CDP, which the Planning Commission had, final authority over in drafting, included language very clearly that we were supposed to, as a city, be flexible when it, interpreting provisions and how you went about applying them. Well, the following meeting, Commissioner Gay came back and said, oh, that only applies to mixed use. Well, guess what? This is mixed use. So why would the Planning Commission go to such extreme effort to find the most convoluted and most broad interpretation of our code to make it more difficult on the applicant? I also want to say that, I don't think I'm mistaken. I don't think Matt backtracked or walked back his position on this. My recollection is that he did say that he could find no other examples in the city, but I don't recall, and I'm pretty sure the record reflects, that he did not walk back his position and he stood by it. And I hope that you can resolve this matter and allow the applicants to move forward. Thank you.
Thank you. Is there any other public comment? Mr. Mehta, please. And then just after this, we're going to take I hope to take a bathroom break.
Yes.
And then we'll get right back at it. So, Mr. Mehta, I'm not putting you on a 5-minute clock, but
I'll be very brief. I just want to rebut an opportunity to rebut, just as Mr. Forson had an opportunity to respond. So, with regard to the statutory language that was quoted regarding whether the Planning Commission is a board or whatever that can appeal a decision, I would submit to you, be very, very careful. I would submit that language does not apply to a Planning Commission or somebody like you when acting in a quasi-judicial capacity, like a court, and they would surely be criticized for prejudging an outcome by rendering a decision that isn't even a final. These were preliminary determinations. The basic concept of appellate authority is you appeal a final determination. These were preliminary determinations at best. That's point one.
Wait, can you clarify that a little bit more, please?
The latter point?
Your first point there, yeah.
So I made 2 points. First of all, I submit to you that when Mr. Forson is reading the language regarding whether a board or a body or whatever has should appeal,
right? That's what
they're referring to a board that's not acting in a quasi-judicial capacity, but rather an administrative capacity.
That's the commission.
Principles of due process apply. You're bound by it, because I know that Mr. Townsend advises you. The Planning Commission, which is bigger than you guys, 9 folks, we cannot make any determination outside a public decision following public debate. The notion that the Planning Commission should appeal a preliminary decision before it renders its final decision on the merits would stand due process on its head.
Okay,
it is a silly interpretation. It's cute, but it's stupid. That's point one. Point two is a basic principle of appellate authority is you appeal final decisions. These were at most preliminary decisions. You can't appeal a preliminary decision. That's clearly what this was. The code says that, and Mr. Janis's own report
So may I ask you a question? So if the Planning Commission is not final, that the Planning Commission could potentially come back and remove some of those conditions?
No. I'm saying that I'm saying the
Well,
decision of the building inspector was preliminary.
Okay,
I
thank
think
you.
he's referring to the June 23 decision that Matt made and the argument that the Planning Commission could have appealed that.
Okay, when you said final, you didn't say building. Okay,
But if you look at the report, and it'd be somebody who's very complimentary of the joint report from earlier this year, it expressly says the determinations are preliminary and subject to change. They're not final decisions that can be appealed. And again, I would respectfully submit that the Board of Commissioners, not the Board of Adjustment, makes the decisions regarding the respective powers of the bodies within the city. On the jurisdictional issue, with all due respect, I think you again have to be very, very careful. You cannot conflate the jurisdictional questions. Do you have the power to act, with this strange concept that somehow the Planning Commission should have, could have appealed the decision? Those are like ships passing in the night. The only question is whether you have jurisdiction. I submit that you do not. So thank you.
Thank you.
Can we ask, since it's been, before you leave, you said a number of times that Matt walked back his decision.
Yes.
Matt is here. Is the decision of the building inspector still that only a single loading berth is required under your reading of the zoning code?
That is correct.
Okay, thank you.
And what I would encourage you to do is listen to the actual hearing and the notice of
sir,
decision.
I respectfully disagree. Whatever was said at that hearing is not what is before this body. Before this body is the city saying again that it is their interpretation through the building inspector that only a single berth is required. That is the factual record we have in front of us. Whatever was said somewhere else is not a factual record for this matter. It may have been for the Planning Commission, but it is not for the Board of Adjustment unless my lawyer, Fred, tells me that we're wrong about that, that I'm wrong about that.
Well, I respectfully disagree, but in all events, if that's your view, then you clearly do not have jurisdiction on this matter.
That we get to decide. You don't get to decide what our jurisdiction is.
I'm simply making an argument, sir. I'm not telling you what to do.
Okay.
So I think there's some evidence in the record that that is in the form of the notice of decision, and I don't know, the record is so big, I wouldn't be surprised if there wasn't something in there that gives the account that Mr. Mehta is giving us today as to what the opinion was. But the best evidence is, the best evidence of the building inspector's view of it is his testimony today, and we just heard it.
Yeah, I'm assuming Mr. Mehta correctly says that something else happened, but that's not part of the record in front of this board, as I understand it, Fred. And that's why I asked the city again, if they've changed their view,
right,
we'd want to know that. But at this point, my understanding is the building inspector says that it is the city's position that only a single berth is required.
Right.
And I believe that's the only evidence we have as what the city's position is.
It's certainly the best evidence of what the city's position is.
Okay, so we're back to something I think was said a half hour ago. Is it? I'm talking to the board. It was before I do that. Is there any other public commentary? Okay, we're going to take a break in a minute, but I just want to make sure that we got what I'm hearing is two paths. One, don't speak to this and let it go to the appeal to the commissioners, or B, as the applicant has asked, is to interpret the building inspector's interpret the code that the building inspector has made a decision upon. We can think about that. Fred, I'm going to ask you for advice. Help us which way we go here. We can take a break and then come back in 5 minutes.
Yeah, and there'll be no discussion during the.
Yeah, no discussion. Yeah, no discussion. Thank you. into session. So as far as, I mean, that's the way I see for the board here and for Fred.
I'm sorry. Oh, you want me to close the door?
Oh, yes, please. Oh, I'm sorry. I didn't see that. As to the way forward here, to not speak to this and let it go to the commissioners, because we are aware of the appeal, or to make our interpretations of the code and either support or not support the building inspector's report on that interpretation.
Are we allowed to have a session with our attorney to discuss this in executive session?
I don't advise doing that. I mean, there might be some circumstance that justifies a legal opinion, but I don't know what it is that I couldn't give a legal opinion or my legal opinion on this matter in public.
Yeah.
There might be some other question I'm not anticipating that you want to ask, and it might be justified for that to be in a closed session, but I don't know what that is.
All right, thank you.
Are we really at the situation of either we take these items one by one that have been asked for clarification, the way we might, many of us probably prepared, so that reading all of the material over and over again, or sending that whole group to the commissioners?
Unless there's a third way. So I'm
Unless-
agreeing.
Unless, and yeah, it seems it's very clear that we have a variance to look at today, the parking.
That is
That is a
correct.
variance,
The
the
off-site.
way,
Off-site.
the off-site
Correct.
parking that we have looked at many times. So that's in one category, and to me, that doesn't have a decision around jurisdiction. That's ours.
That is correct.
So then we have these other items, which we've just spent a lot of time on, the loading dock or berth. And we have those other items that are primarily height-based with the loading dock. So it seems to me that's our jurisdiction decision point, is what do we do about those? Do we do clarifications on those, not variances, but do clarifications as we've been requested by some folks, or do we send it to the commissioners and say, this is not in our wheelhouse, this is yours, or is there some other? I'm just sitting here not knowing where to put my head.
Yeah, they're the two I see.
Can I suggest one other possibility? That could we not look at the code and say, and agree that it is perhaps ambiguous? And of course, we can send it back as noted as ambiguous, which case, according to the code, it would go in favor of the applicant?
Well, that's the one option. The second one, and make the interpretation of the
Right,
code.
the
That's an
interpretation
interpretation.
that we can't.
So we're still
we
at
can
two.
interpret that we can't interpret it.
But I have I have a question. My understanding is that the parking lot, they're asking for a variance for. And, I'm sorry, I'm not quite close. My understanding is, I mean, I went over and looked today, there's no variance sign in front of the Baltimore Avenue parking lot.
Okay, all right.
Nor has there been any.
So-
Yeah.
Why don't we really do, I think, need advice from our lawyer about what our powers are, because we are a body of limited jurisdiction under Section 270-74 sets out our powers. So I guess I'd like to know what power we have to, what is it we can do with a matter that's in front of us? Because there isn't a variance requested in front of us. That's not been, that is not the way they've noticed it. There doesn't really appear to be an appeal from a decision of the building inspector that is in front of us. What we think we've been asked for is to give an advice or an interpretation of, I'm not quite sure what. Is it our interpretation of the zoning law? But we are not supposed to be doing that. We take appeals or grant variances. So Fred, what is it that we have the right to do here?
Okay, so this is a very hard question. I mean, I don't.
We don't like to ask you easy questions.
No, I know. I know.
only
You can
deal with the
handle
tough
you
stuff.
can handle the easy ones.
Yeah.
First of all,
Thanks.
I mean, it's clear that appeals from planning commission matters where they're exercising their authorities, which have to do with the protection of architectural massing, composition, scale, character of the neighborhood, preservation of streetscapes, protection of public health, safety, and welfare. Those are the types of things that are not in our domain. Those are in the site plan review process is firmly in the domain of the Planning Commission, and I don't think anyone on this board wants to interfere with the Planning Commission's authority. I think that is understood and agreed. What we have is an incredibly unique situation in which there's some disagreement as to what the record might have been before the Planning Commission, but the building official is stating today his interpretation of the zoning code. And it is this body's responsibility to make interpretations of the zoning code. And it is not even the commissioners, the Board of Commissioners' responsibility to engage in the interpretation of the zoning code. They draft the zoning code, but the authority to interpret the zoning code then falls on us. I wish I could say that I had that there was just a straight line answer to this question. I think Mr. Mehta makes a strong case, and I think Mr. Forston makes an equally strong case. I, however, am less, if forced to offer an opinion, I am more persuaded by the substance than I am the labels that are attached to the posture that we're in. I mean, again, I reiterate, we don't hear appeals from the Planning Commission. So when the Planning Commission says your project is code compliant, but for reasons related to the preservation of streetscapes or massing or composition or scale, we think you need to make an accommodation, or you need to enact, or you need to incorporate certain other features or avoid incorporating certain features. That is their domain and not ours. But the posture of this, if we were to hold fast to that principle, the posture of this would then send an interpretation of the zoning code, a set of interpretation questions to the Board of Commissioners who are elected officials. And these questions are generally not supposed to be answered and aren't answered in that kind of a context. The zoning interpretations, all roads, as was pointed out by Mr. Forston, lead to the Planning Commission. I know I've said it a number of times without ever imagining this circumstance before, that we are the final authority.
You said Planning Commission, did you mean Board of Adjustment when you said all roads?
Oh, if I said that, I'm mistaken. All roads lead to the Board of Adjustment.
Why don't you clarify that, because
Okay.
this is going to court.
So I have said on a number of occasions before us in different contexts, that something to the effect that the Board of Adjustment is the final authority on the meaning of the zoning code. And I never imagined we'd have a scenario like this one. I do feel like I'm sympathetic to the argument that Mr. Mehta makes that the Planning Commission is really not well suited to lodge an appeal within 30 days of something. I mean, they have to notice their meetings, they have to post an agenda, they've got to deliberate and then decide to appeal. I mean, I just don't know how that appeal period would work. So I have a practical concern about the significance of that argument. But on the other hand, I'm troubled by the idea that a posture could be created in which the commissioners are exercising an authority that I believe is reserved to us. It's, in an odd way, the applicant would be much better off if Mr. Janus did walk back his interpretation. If he were to walk it back, then we could clearly have an appeal or something that is more common for us.
So that gets back to your substance over
Substance over form, yeah. I think the substance of this is that we're put in a position to exercise authorities that are reserved to us in the state code to interpret the code. And I don't think it's an easy case. I think, as you've heard, I think two very sincere competing positions have been offered. I think both parties believe in their hearts what they're saying. I just, I don't think we should consider as an alternative to exercising our authority that we'll just leave this for the commissioners. It's not a reasonable, that's not an actual consideration that this board should rely on in making a decision.
Fred, you know, on the clear space, there was appeal to the clear space decision, and that decision went to the Board of Commissioners. It did not go to the Board of Adjustment. And it was based because that was the code required it to go to the commissioners. And there was also, and it had to do with area variances and all of the things, but it went to the Board of Commissioners. So,
Well,
you know, and at the time, because that was what the code said to do, appeals had to go to the Board of Commissioners.
But I'm not as familiar with that case as I'd like to be, especially right this minute. But I don't know if the building official in that case had given a contrary interpretation of the code.
He did,
to
actually.
what was accepted by the planning office. Well, I will also say so argue, let's say for the sake of argument that actually happened. That doesn't mean that it should have happened. It doesn't mean that we're bound by that and that we shouldn't make our own determination as to what our jurisdiction is.
But what is it that we would be doing? And the Planning Commission has issued its decision. We have no jurisdiction with respect to that decision. The jurisdiction there goes to the city commissioners. We could, I'm not quite sure what it is we have the power to do here, Fred, because there isn't an appeal from Matt's decision. We would be, I guess, be giving our interpretation that the Planning Commission should not have done what it did. But that, I'm not quite sure that we want to get into that. To that
No,
either.
I don't.
So
We're not going there. But
so I don't know.
I think we're back to interpretation of the code. So,
But what does it do? If we interpret the code, what does Papa John do with that?
So I asked Mr. Mehta that question, and he didn't have a ready answer, but I don't blame him for not having a ready answer. Mr. Forston's answer to that is, well, there are 4 items here that we're appealing from, let's say, and those items no longer, those are no longer pending legal questions because the Board of Adjustment has settled them. Then, in the absence of any additional variance issues, I think the appeal could be withdrawn and an application, whatever the next step in the development of the project would take place. Ultimately, there would be a permit pulled and the building official would be bound by our interpretation that no variances were required for a second loading dock, or if we get to it, the different relative height issues that are before us. I think I'm guessing, that's my view of what of how this would play out.
That we would issue a decision saying, just on that hypothetical, decision saying that, on the record before us, it is our judgment that no variance is required with respect to these two, to the two applicable provisions, and they would have that decision in their hand. They would also have the Planning Commission's decision in their, the Planning Commission has said in their view a variance is needed. And then I guess the city then decides whether to grant a permit, and then they refuse to grant it. They go to court to get a permit. I'm just trying to figure out what.
Yeah.
So where this is going. Maybe I'm getting too far
I
ahead.
mean, I guess we could ask Mr. Burns what might happen next, but I think if...
Maybe we could also ask Mr. Forston what it is he's asking us for.
So I believe what he's, and I'm sure he'd love to tell us, and has. And you don't need to ask him twice.
I noticed that.
But I think his view of it is that if we settle these issues, the variance is another matter. The off-site parking is a different matter altogether. Right. But these issues where we have competing interpretations, if we were to conclude, based on the record before us, that no variances were needed, then I believe the applicant would be able to withdraw its appeal to the commissioners and then proceed with the development of this project, and that the contingencies, if you want to call them, the contingencies of approval that were linked to the department or the planning office's decision would no longer be contingencies.
Because we haven't even gotten, in my view, to the merits of 1 versus 2, because I think we spent 2 hours addressing jurisdiction.
So that would be if that we would do that if we got, we would do that if we were considering whether to grant relief from the zoning code. We would get into the merits. We'd have the authority, and we would be on our, in our bailiwick then. Right. We would know what tests to apply, and we would take testimony, and we'd proceed.
Well, on this loading berth, I was playing with some wording earlier. Would we do something like that we confirm, as an example, that only one loading berth is required according to zoning code, so no variance is necessary? So, I mean, that's, to me...
That's what the applicant would like from us.
Right, and I'm not saying that's what we're going to do or that what we should do. I'm just saying, is that the kind of statement, though, that would move the applicant forward out of this morass that we're in, where we don't know what or I don't know exactly where my head should be in crafting decisions or comments for moving forward.
Okay. But I've heard Fred say about 5-10 minutes ago that it's not, I had said earlier that there's 2 paths.
Yes.
Go to the planning commission, let the applicant go to the commissioners, or we work on making an interpretation of the code. Is the board open to going down the path of working on that interpretation of the code, and then voting on a motion to affirm the building inspector's interpretation and building inspector report, or to not affirm that?
Okay, I'll go first because you're looking at me.
Thanks, Bill.
Yeah. I'll have to say, I've come to the judgment that we should get to the merits and address that question. It's not where I was at the beginning, but for the reasons Fred said, I believe that it is our responsibility to be interpreting the zoning code. And I think that I'm convinced that that issue is in front of us. I don't actually know where I come out on the 1 versus too, because we haven't really done that, but
We haven't debated it among ourselves.
well,
yet, right?
actually,
Yeah.
I'd like to, for example, the doctor said he wanted to address the merits. I actually think that it's worth hearing that, because we just said to everybody, we're addressing jurisdiction. I guess I've come to the judgment that this is within our jurisdiction, as Fred said, not to let the specific process get into the substance, and the substance is we should be the ones who are determining the zoning code. Hear again from Matt as to why he came to the judgment of one. Hear testimony from anybody who wants to in terms of single establishment or multiple establishments, and then rule on that. And then if we come out saying that one is fine, we're there. If we come out and saying that you need more than one, I think they have to then apply for variance, because they've not applied for variance.
That's correct. I don't see any scenario where we're going to move forward with a variance request based on the papers that are filed and the lateness of the day and all the
On any of
notice,
these-
all the notice requirements.
Yeah, on that or the height issues, because that's, we're in a different avenue if we do that. But I'm with you, Bill. I too think we've got to get off the dime here. And it seems like it's our responsibility to make interpretations. I mean, why do you have people who do this kind of thing if you don't use them when you really need them? And this seems like a situation where the city or our community needs our quote-unquote expertise with the zoning and our considered opinion, and to make some confirmations or suggestions or whatever we're going to do.
I disagree. I think the city has a process, and they've used it in the past when there's been a disagreement. And whatever, it has worked or not worked, but I'm only familiar with the one. I don't know if there's been any more. But it's very, when I was on the Planning Commission, there were times that we wanted to appeal the building inspector's decision. But we felt it was unseemly, essentially, to have one person, one city quasi-judicial filing a suit against the other city quasi-judicial. And so we never did it. But I think there is a process here. And I think that Mr. Forston I just don't think it's our job to interpret the code. When there's between the Planning Commission and their applicant. I think it belongs to the City Commission. That's what the code says. That's what they're prepared to do, and hopefully they'll do it well. And then it'll come back to us for the items that actually need a variance. And I just, certain things are relatively innocuous, a fence around the roof or and an antenna, but a loading dock isn't. And I don't know how many of you have walked down the alley behind Wilmington Avenue. I mean, when they say that there's not loading docks behind all of these places, these are old stores, and they didn't have the kind of deliveries, in Rehoboth of 50 years ago. And they didn't have the hotels, and they didn't have anything. So now you have on the second block of Wilmington, essentially a row of dumpsters, because there's no place to put them, because these things weren't thought of that many years ago. And you have people living, there and all this stuff. And so now you're building something new. You have an opportunity to say, what is the best thing to do for the city and its residents and the look and feel of the city? And that's why you have site plan review, to allow the Planning Commission and the time. I mean, we're sitting here and it's been 3 hours and we're still talking about loading
but we're
docks.
just discussing whether.
But you may have the
we
votes.
should-
I just think that there is a process in the city code, and I think we should follow the process.
Okay, thank you. Mark, thoughts?
I just sort of respect the Planning Commission in that they took the opportunity to look closely at the whole situation and decided to add additional comments, additional requirements. The fact that those additional requirements were not what the applicant wanted, so be it. I just don't see that, I don't know, as far as the legality of us making a decision, I trust what Bill said. He has more experience with law than I do. I think he's absolutely right.
Not a decision, the interpretation.
Right, interpretation, yeah. And I've read it, and I interpret it to be ambiguous. I mean, honestly, I don't think Matt made a mistake.
Okay, before-
I think he just read it different
Yeah,
than I
before we
did.
get into that, so you're in support of what Bill is saying we should move
Yes.
forward, and Edie, and I too agree that we should move forward and give our interpretation of the code to either support or not support the building inspector's interpretation of the applicable codes here. And I'm sure this is going to come back for, for the antenna and for the railings as well. We're going to have to go through this, hopefully, a more condensed approach. But I do think we should move forward. And so we are done with public commentary.
I just have another question.
Mhm.
If we do move forward,
Mhm.
and then, if we do move forward, I mean, we're going to move forward because I'm outvoted, but if we move forward, and then if somebody wants to appeal our decision, then they have to appeal to Superior Court. Am I correct in that?
Somebody wants to,
Appeal.
if we move forward on this one,
Right, and somebody says you shouldn't have moved forward,
Right.
another lawyer, do they appeal it to Superior Court?
I believe that they would, yes.
Okay, well, that's why I just want to make sure that I understand that.
Yep.
Okay.
Okay, so we've talked a lot about this. We're going to discuss the building inspector's report, and I'm going to open it up for commentary from the board at this point. Look down to Mark.
I repeat what I've just said, that I think that the code, I've read it several times and end up having to do with this issue. And I could fall either way on it, so I do think it's ambiguous, and that word is perfectly descriptive of what it is. And,
Okay.
and that's how I would vote, and that's how, once that's done, there is a process for an ambiguous code. And happens to fall in favor of the Papa Johns, so be it.
Right.
Yeah.
Edie?
I would love to have this all be easy, but that's not where we are today at all. And I'd love to be able to be the person to solve the general congestion on Wilmington Avenue, and that we have all actually in the Ocean Block on many, many streets, for the reasons that Jan just mentioned with her previous discussion, is an old town built with small things and not wide streets. And but I don't think that Matt made a mistake in he and the WM in the report. I don't think he made a mistake in his interpretation. I think that one loading dock is sufficient from what I read. And then when I look at this drawing that was in our packet, and being on Wilmington fairly often as a local, where else would you put an entry into it for a loading dock or anything? I don't. Anyway, I feel that the interpretation I agree with the building inspector that his interpretation was correct, and I would stand with that.
Okay, Jan?
I actually disagree, obviously, with the building inspector on this, and I think that we have an opportunity here to do the right thing, and in a new construction to do the right thing, and so I think that the building inspector's decision was not correct. I think that that actually you could add a second loading dock without impacting the overall building. And I think they even had plans at one point for a second building dock without impacting the overall building. But I don't have them in front of me, so I can't, so I would vote no, if you're asking me.
I take it from earlier remarks that you made that you might vote no because you don't think we have jurisdiction to take.
Well, I don't
essentially
think we have
appeal.
jurisdiction, but if you're asking me to make a decision, if everybody voted against me, and you're asking me to make a decision, on the loading dock, I have a huge concern about loading docks, huge concern. And we lived in the first Ocean Block of Olive Avenue, a very wide street, really wide, and still dealt with, the Boardwalk Plaza and Obies, and trucks parking there and leaving their engines going on forever and having to call the police. It was just, and Wilmington is like so narrow compared to Olive. And so I would vote no. I think you need two loading docks.
Okay, based on your interpretation.
On
of the
my
code.
interpretation.
Yes, okay.
Right.
Bill?
Yeah, I guess we didn't really get into a real discussion with Matt in terms of where the source of his
We can still ask,
interpretation. So I would like to ask because I do think that it's a very close call in terms of the language, 15,000 square feet in commercial. I think, what is the language here? The question is whether it's individual or collectively. The 15,000 square feet. So can you talk to us, Matt, about what the thinking was? In your experience, has this issue come up previously? And if it hasn't, what is the thinking as to whether it is collective, where it says retail or service establishment or other commercial use with over 15,000 square feet?
Thank you. As you know, we have no mixed-use code ordinance. And so we are forced to hodgepodge together codes to get interpretations, which is not the best way, as we know. For this particular application, I viewed each occupancy as a separate occupancy. Though it is one building, each occupancy requires a separate business license to be able to perform their function. So that in itself tells me that it's a separate occupancy. It cannot be combined with another occupancy because I might have a restaurant, I might have retail, I might have a candy shop. Those are not the same uses, nor are they the same building code requirements as say, retail collectively would be. And so because of that, and because we don't have a mixed-use ordinance, we did the best available to us. Each occupancy itself does not make the 15,000, and so therefore, those do not trigger an individual requirement for a loading berth, but a hotel does. And so because the primary function of the building is a hotel with ancillary occupancies with commercial, that's where that determination came from.
May I ask a question? I don't want to interrupt.
Sure.
If you're right on them. So Mr. Trejos made some remarks and made them well, and said that in his mind, the merging of lots is what triggers the need for an additional loading dock. Did you consider that? You heard his testimony. It's not your view that it's more based on the uses and the square footage of the individual uses than it is the square footage of lots that are to be combined that helped you make that determination?
Yeah, I believe that's correct. Because each occupancy requires its own separate legitimization, if you will, I can't group that with another occupancy and say, oh, well, it's the same building. Now I have, and again, this directly relates to our lack of a mixed-use ordinance. And so hodgepodging the code together, this is the best interpretation that we can make.
Put another way, you'd be in a situation where some individual small unit could throw over the total over 15,000, and then you'd end up with the issue of who's got to put the loading dock in. This new 1,000 square foot small novelty store has kicked it over 15,000.
Right. And I would agree with that statement and also add that let's just say that whatever happens to this application and it comes before us as one occupancy for the totality of the retail area, we still have the power to say you need a loading dock for that particular application because you're over the 15,000 square feet.
Okay.
You good then, Bill?
Yes.
Okay. And I too, I'm leaning towards the affirmation of the building inspector's report. a best or at worst, you could say that code, I agree with Mark, is ambiguous. You know, I kept looking at retail establishment. Okay, there's an establishment, and I too feel that the building inspector read the zoning code correctly and made the proper decision on saying no variance is needed. So with that, I know, Jan, did you have an additional question you wanted?
I just wanted to ask Matt, how did you, excuse me, in looking at the First Street station, where the courts determined they were all, even though they were all different ownerships and had a different business license, they were still considered one business, okay, as far as liquor license. So do you have a different standard for liquor licenses than you do for loading docks? Because they have a loading dock.
Absolutely. There is a different standard, 100% for a liquor
okay.
license.
No, I just, okay. So one works for one way and one works for the other way.
Well, it wasn't one business, it was one building, I think.
I thought, no, it's one building, and so is the hotel, it's one building with lots of different owners, okay? And that was First Street Station, one building with lots of different owners, each one having a separate business license.
Well, the argument that was being made there was that it was two buildings. That argument, I think, is what failed. The argument that was being made was it's two buildings, and therefore we can have two
Right,
alcohol
I
serving-
understand that, but the courts ruled it was one.
Right.
And that's what I'm saying, with his analogy of each one having a separate business license. So it's not one building. It's however many different businesses. And that's not what the courts ruled in First Street Station. But it's okay, I lost, you know.
Well.
May I get a motion for the loading dock
What kind
topic?
of words do we want to use? I mean, should I try? I move that we confirm that only one loading berth or dock is required according to code, so no variance is necessary.
Or could we soften it a little and say, due to the fact we find code to be ambiguous, therefore only one is necessary?
I don't think the code is
can do
ambiguous, Mark.
It just, I think it
Then
doesn't.
I remove my motion, let's restate it.
I'm just offering a suggestion. If you
No,
don't.
no, I-
You
no,
could-
that
you
never
could try to
hurts
make-
my feelings. Never hurts my feelings.
Well, I think the motion is fine. I think if you support the motion for the reason
Oh.
that.
Oh, all right, yeah.
That
Right, that's
you
the
think it's
public record,
ambiguous,
right.
then you would make that, you're right, you'd make that statement.
Okay.
Okay, so I
apologize.
reinstate my motion that I just retracted. I move that we confirm that only one loading berth or dock is required according to code, so no variance is necessary for the applicant.
Okay. May I get a second for that motion? Second. Okay, we're going to,
I'm in favor.
and your reasons again?
Oh,
Hate
the
to make-
reasons is I find the code to be ambiguous, and when it's ambiguous, it comes down on the side of the applicant.
I'm in favor because I believe that the building inspectors, I concur with the building inspector's view of this particular situation and feel the lack of a multi-use zoning situation that we could really count on.
You mean mixed use, yeah.
Mixed use,
yeah.
oh, I'm sorry,
Yeah.
I'm sorry, mixed use, excuse me.
Okay.
My error.
Thank you. Jan?
I'm abstaining because I don't believe that we should be voting on this. I believe that there is a process in place in the city for hearing these types of appeals, and this is not the process. So I'm abstaining.
Okay.
Is that all right?
You're abstaining?
I'm abstaining because I think we're not doing the right process.
Well, I suppose you can abstain.
should I
but
just
you
vote
can-
no?
But you can vote no. I mean,
All right, I don't believe we're following the right process, so I vote no.
Right.
I support the motions for the, motion for the reasons that Edie stated.
And I too support the motion based on what Mark said, that at best or at worst, it is ambiguous, but I believe Matt interpreted the zoning code correctly.
Can I ask Fred a question? Not to do with
So
this.
this
Right,
passes.
Right. And that is, we have 2 things left to do, and it's 20 of 5.
More than that.
No, we only have 2.
We have.
Three things.
We have 2 height-related questions,
Right.
and then we have off-site parking variance.
This is variance.
Yeah, but there was no signs posted, there was no notices given for that variance.
So now's a good
so-
time to talk about that. So this is confusing, and I think let me try and explain. So you're focusing on the site that the applicant would like to use for off-site parking. And
Under the variance.
on the variance, and you're saying, why isn't a sign there? Why isn't it posted for?
And why didn't the neighbors receive a notice?
Okay, well.
Okay.
So let me try and answer that. Now, I might need some help from Matt on this, but if a standalone parking lot is a permitted use on that site, then the neighbors don't need a notice telling them that that is going to be used in accordance with its zoning.
Then it doesn't need a variance.
Well, no, the issue.
That's what I asked you before. It doesn't need a variance.
So they do. The variance is elsewhere. The variance is from the strict enforcement of the code that requires on-site parking for 116-room hotel, I believe, is what's being sought. So what they're asking for is relief from the requirement to place all of the parking for their hotel on-site. And they're offering as a condition, hey, we're not just saying that the last 24 guests of ours in those last 24 rooms got to fend for themselves in terms of finding parking on the street. We've got a spot. We're going to use valet parking, and we're going to send the cars over there, so we'll have sufficient parking here, and we will alleviate any parking concerns.
So they want to go from a 92-room hotel that was approved to a 116-room that was not approved by the planning.
116 was approved on the NOD.
Not by the
Right.
Not by the
Right.
planning commission and
Right.
site plan review.
That's absolutely true. And I don't know if we grant that, I think that means that they have to go back to the planning commission. But anyway, do you understand why that?
I do,
Do you
but
understand why that site was not posted?
No, I don't, because I still think that the people who live on that street, first of all, that's not wide, it's only 23 feet wide, the drawings were incorrect. But secondly, I think there is, I think there's a lot of work around Baltimore and Wilmington Avenue streetscape. And I think that if there was I think at this point, there was some serious discussion. I understand it's already licensed, but if there's some serious discussion about allowing more cars there,
Well, let's stop. Can we ask, Matt, is that a permitted use? Because if it's not a permitted use, then they need to make a different application.
The parking is a permitted use for that zoning designation. The variance request is for the distance located off-site.
Right.
And
Yes.
to your comment, they are not increasing to 116 rooms. They're staying at their normal room count, and they're not
Wait a minute,
requiring additional rooms.
All right, well, I'm not sure about that.
I'm not sure about that
I haven't
either.
seen plans to
Well, it doesn't mean,
suggest
if they
otherwise
they
yet.
haven't gotten the variance yet, Matt.
But
Wait
if
till
they get the variance, I think the door is open for them to go back. Right. But, and we'll hear on that. But I don't know if we want to hear the variance now, because we were so close on this issue of these height things. Do we want to move to those?
Let's do the
I would
height.
like to move
Let's do the
those
height.
last two in the same order, and we may have to.
I have no
defer the
problem with the height. I don't understand. I thought that when somebody says antenna, my assumption is it's like a metal thing that sticks up like you have for cell phone towers and things. But I understand from talking, to an architect or to some people, that it's actually an architectural.
Hold on, before you go too far, I want to go back to.
It's on the rendering.
Let's allow the applicant.
Yeah, I want to allow the applicant.
And
if he
you can
wants to
ask
say anything
questions.
about if you want to do do you want to merge antenna and railing together as your,
No?
or you want to keep them separate?
So,
I think they're separate.
Mr.
Okay.
Chair and members of the board, first off, thank you for your decision on the loading berths. Let me just real quick address I'll say some confusion about our variance request, and then I do want to address the height, and maybe we have to do the parking at another time.
Can we, since we're going to do the variance later or even maybe another night, can we just focus
On the antenna, let's do it
on the
antenna.
antenna?
Okay, I just thought it might be helpful.
Well, the
to answer
antenna and the
this.
fence. Oh, you don't want to do them
I don't
together?
want to do
Oh,
them
okay. All right.
Unless
Sorry.
the rest of you do. I mean, do all of you want to do them bunch them together?
They have different reasons, but
I think the antenna and the safety railing, I'd like to think you'd approve them both for the same reasons, but so we can discuss them together or we can discuss them separately, but if we
you wanna
discuss them
put 'em
together, it
together,
might
it's
go a
okay.
little faster.
It's okay with me. I know, I can keep my set.
But then how can we vote on one yes and the other no?
You can,
Well, he can discuss them
That would
together.
be the problem.
we're
you can
discussing
make
them.
as many
We
motions
can make
after,
motions.
when it comes time to making
Okay.
motions as you
All
need
right,
to.
I agree. That's good.
All right.
That's okay, guys. Sorry.
Okay, Peter, can you just get the latest plan up so we can show people what we're looking at here? This is the old hotel that we're trying to evoke, but can you call up the latest iteration rendering? I know it's on your computer. I would do it, but I don't want to break your computer. Just show the latest iteration of the building that takes into, it shows the antenna and a view of the roof. Okay. This is the current, based on our current, okay. So here we have coming up on the screen, kind of what the roof looks like from the streetscape. And we're asking for well, our plans show an antenna, and the Planning Commission was clear with us that if you're going to have an antenna, it needs to be a functioning antenna. It will be a functioning antenna.
Doing what, please?
Getting FM, getting TV, getting something. It will be a functioning antenna, and if it's not, Matt won't give us a permit for it.
Will you need that height for the use that you're going to have?
Well, so here's the thing. Antenna are exempt from the height requirement in the code. And so we never thought this was an issue at all. I mean, the previous building inspector never identified it. Mr. Janis never identified it as an issue. Wallace Montgomery, or Montgomery Wallace, I forget the order of their names. They never identified it as an issue. We were in front of the Planning Commission for a year and a half, I mean, almost a year and a half. And it was only essentially at the last meeting that the issue, someone said, well, isn't this antenna too tall? And we pointed out that the antenna is exempt from the height requirement.
Can you put up the other picture? Because this is the old two-story
Oh, can you go
building.
back? I'm sorry, go back to the other. Okay, yeah, there you go. And so the idea was, if you remember what the postcard showed you, there was a spire on the top of the Belhaven. And obviously, we think it's a nice touch, and we wanted to help recreate that feeling and flavor. And I think somebody said modern amenities, but yesterday's charms. And that's what that is designed to evoke. And we'd still like to do it. And it says in the height restrictions, I'm just trying to find where it talks about antenna here. Just bear with me a second. Heating, ventilation, and cooling devices, which are to be enclosed so as to be obscured from view, elevator shafts, one stairway entry for maintenance access to the roof, chimneys, and antennas shall not be included in calculating height. So, we were directed by the Planning Commission, if we wanted to have this antenna, to come to you and get a variance for it. But the code tells us that antenna are exempt from the height requirements. So for the same reason that we just went through on the loading dock, we would ask you to also confirm that no variance is necessary for the antenna because it's not subject to any height limitation. That's what the code says.
Are those the solar panels that you're not going to use?
Yeah,
down
some of
there?
those things are
Okay.
solar
That's what I
panels.
was asking
yeah.
for a picture early, when we first started.
Yeah.
Yeah.
These pictures have the solar.
Our pictures still have the solar panels. I apologize for that. But, we were also told, we had always assumed that the solar panels, like heat, were kind of in the same category as heating, ventilation, and cooling devices because they're used to power and whatnot, the building. But the Planning Commission said, no, if you want solar panels, get a variance. And so, as I said, no good deed goes unpunished.
And where is the fence? Is it?
So you can't see it.
Okay.
And the reason you can't see it is because it's not at the edge of the roof. I mean, it is set back away from the edge of the roof. It is there, you say fence, I call it safety railing, but it is there solely for the benefit of the guys who are going to be up on the roof from time to time working on the HVAC, and for no other purpose. The public is not going up on the roof. And so we had always believed, and I believe that the building inspector agreed, and again, Wallace Montgomery never flagged this issue, that if you're allowed to have heating, ventilation, and cooling devices up on the roof, the safety railings that go along with those devices are part and parcel of those devices. And so we don't need a variance for the safety railings for the same reason we don't need a variance for the HVAC. Otherwise, think about it, if I want to put HVAC up on my roof and I don't need a variance, but then I need a variance to get the railing to protect the workers, I'm going to always have to come to the Board of Adjustment for a variance for the safety railing. So I think everybody, up until the Planning Commission conditions were imposed, were of the view that the safety railing was part and parcel of the HVAC, because I say otherwise, we're always going to be coming to you. Or I suppose if you deny the variance, I don't know what the workers have to do. Maybe they tether themselves to something, but it would be a less than ideal situation. So on those two issues, the height of the antenna, which is exempted from the code, and the safety railings, which we believe are part and parcel of the already exempt HVAC, we don't believe any variance is necessary. If you want to grant us a variance, that's fine, but I don't think they're necessary. And we would ask you, for the same reasons that you just gave for the loading berth, that you also declare or interpret the code in such manner as to say that no variance is required for either of those two things. And then, as just to finish setting the table here, as Mr. Townsend has alluded, if you agree with us on both of those issues, then I think we will be in a position to withdraw our appeal to the commissioners, and we're not going to challenge any of the other conditions which the commissioners imposed. And just for the record, and so we're clear, we still do obviously want an off-site parking variance. And if we got that, I do believe we would have to go back to the Planning Commission to run that past them. But with a variance in place, granting it, I mean, and with having already reviewed all the other issues related to the building, I think, I need to knock on wood, but I think that we would be in for a much shorter process. But we'll talk about the parking variance when we get to it. Right now, I just want to talk about these two height issues. Thank you.
There's no questions for Mr. Forston. We're going to turn over to Alex and Matt to
I have
any
one question for Mr.
Oh, you do? Okay, hang on.
Is the entire antenna functional, or is it more decorative? Is it an antenna with decorative pieces on it, and is that what the Planning Commission objected to?
So the code says that actually the antenna at first didn't have any decorative stuff, but the code says that antennas are supposed to be obscured. So we added obscurity, if you will, to try to disguise the antenna. And I think it goes more towards your point, which is cell towers. If you're going to do a cell tower, people want the cell tower somehow disguised. And that broad language just carried over. But it will be a functioning antenna, or else, and we'll have to demonstrate that to the building inspector's satisfaction, or he won't give us the building permit for it.
And will you demonstrate to the building inspector that the height of the antenna is only sufficient for the item that it's servicing? In other words, why do we need a 50-foot antenna for a 3-foot radio?
Well, we're not, the answer is, it's also decorative, but as long as it's an antenna, I don't think it matters. We're not going to put a 100-foot antenna up. I forget what the actual measurement is. I think it's 70-some feet, if I remember correctly.
I think it's
makes the
11
feet
and a half feet
11 and
above
a
the
half feet
50.
above 50.
Above the
Okay,
50.
so 11 and a half,
Above.
yeah.
Above
Okay.
the
Over the
Above the
cupola.
50, above the 50.
So 61, 62 feet. And that's about 20 feet off if the roof is at 42, which it has to be, so that's about a 20-foot antenna.
Okay.
So I have a process question for Fred. And that is, do you do the same thing if you're doing this? Do you just say they don't need a variance, or do you have to give them a variance for each of these things?
So the applicant is not asking for a variance. If they were, they'd be making a different case. They'd be saying they've got an exceptional practical difficulty. So instead, they're asking us to treat this the way we treated the last application, which was to conclude that based on the record and the building inspector's interpretation, that no variance is required.
Okay, any other questions for Mr. Forston?
Only one, and this will just be used by you. You won't be selling space on the antenna to outside entities or anything like that?
Correct. This is not going to be a cell tower for anybody else or anything else. This is intended as an antenna for the hotel, and I would be less than candid if I didn't say part of the allure of putting this antenna in place was to have a nice architectural feature that evokes the old Bellhaven.
Just wanted it on the record.
Yes, thank you.
If you're not sure exactly what technological attributes it's going to have, how can you talk about how high it needs to be? Or, I mean, you say it's going to be functional, but I wrote to be determined because from your previous answer, or maybe I misunderstood you.
It will be functional, and we will limit it
to do what?
to the height that we're showing. Well, it'll get FM radio, it'll get AM radio, it'll get ham radio. I mean, it will receive signals and be a functioning antenna. I don't know how else to answer the question. I mean, that's all that I have to show in order to be exempt from the height requirement. It will be a functioning antenna, or it will not be permitted.
Okay, all right, we're gonna let Matt, Alex, any response on this?
I have two comments. First, to the railing in building code, and this goes beyond zoning code. In building code, there are certain requirements for safety railing to maintenance and maintain and service the equipment. The second thing that I would just like to add is the FAA has height requirements for antennas, et cetera, so that I would just caution the applicant to make sure, because we do fly banner planes, et cetera, they just contact the appropriate authorities concerning FAA heights, so that they are not putting themselves into jeopardy with the overall height of that.
Good point.
I have some questions.
Questions for Matt? Mm-hmm.
Yes, please.
Yes, ma'am.
So Matt, on to the antenna first. Do you have any comments about, are there any other words or strictures about antennas? I mean, I found the 27020 talking about the antennas, and then I found a definition of small wireless communication facility. Is that what it's considered part of? Because it says the structure on which an antenna is mounted, 50 feet or less in height, no more than 10% taller than other adjacent structures, not extended to a height of more than 50 feet by more than 10% of its pre-existing height as a result of the co-location of new antenna facilities. I don't know how much or all of this applies.
That's the small cell tower statute, right?
Yeah, that's correct. So that ordinance was brought in to address cell towers specifically.
Okay, thank you for the clarification.
No problem.
Let's see. And then I read the definition of antenna, an apparatus designed for the purpose of emitting radio frequency, RF radiation, to be operated from a fixed location pursuant to FCC authority for the provision of wireless service and any commingled information services. So do you feel that what they're proposing fits that definition?
The applicant is telling me that they're putting an antenna in.
Mm-hmm. That's what I got from Mr. Forston.
Yeah, so I have to take the applicant on his word that that's what they're putting in. Until I see something different, then I have a different interpretation at that point.
Okay. Just a reaction I have, I'm feeling, at least about this, that, bless you, whoever sneezed, feeling that the applicant wants the hotel, especially because it doesn't front on Rehoboth Ave, which is their address, to be the highest, most eye-catching and visible item as one walks down the boardwalk. And they're doing everything in their power to enhance the presence at the prestigious Rehoboth Avenue spot, even though it's a Wilmington Avenue main address. That's just an observation that of my own. And I had the same question that Mark had. Can can their antenna function be achieved in any other way by the antenna in this location or at the height they're proposing? And I suppose you're saying that'll be obvious once they have a building permit or?
Yeah, they're going to have to determine exactly what the use of that thing is for the building permit. So there'll be a record, specifically saying this is the intended use. And at that point,
Then
if
you
it does
match
or doesn't meet code, I give or don't give a building permit.
Okay. That was all that I had for on the antenna. Is there anything I should have asked you about the antenna that I did not ask you?
Maybe just the passcode so you can use it yourself?
Good point.
I don't know.
Moving on quickly to a shorter list from the safety railings. As we say, that it's a part of they consider it's part of the HVAC system, so exempt from height restrictions. Do you agree with that determination, or how do you feel about it? What nuances do you feel that might be in that observation?
I think I go back to my previous statement that the
Okay.
code is actually required. And so in safety situations, regardless of zoning ordinances, I have to put some kind of protection up there for my maintenance workers.
Sure.
So could you approve the HVAC in that location without the safety railing?
Yes, possibly, but depending on proximity to edges. So that's where it becomes more important is building edges. That's where we need the safety railing in place. When in close proximity to, for fall protection, that's where they are required at that point.
And that includes even a slightest sloped roof? I mean, that's an edge, right?
Not slope, equipment.
No, I'm saying from, I recall, I'm sorry for jumping in here, Edie.
No, that's okay.
There's a pathway, I think it's in the center, but I don't recall if the roof slopes down from that pathway or if it's flat.
Well, I would think there would be some minimal slope to
For
get some
rain.
drainage.
Yeah, okay.
But I don't believe we're at the phase or at that point to determine if there is any slope present in the
But
drawings.
Would that constitute the edge? If
The
you follow
slope of
me?
it?
Yeah, if it's the slight. In other words,
No, because the code doesn't say it's the slope and this is required. Other OSHA comes into play when you start
Okay.
talking about slope. But this specifically says within a certain distance of an edge of a building.
Got it.
You have to put this
Have
in.
the railing, okay. Sorry, back to you, Edie.
Sure. How high are the proposed railings? That wasn't part of the applicant's information that I read.
Code would require them to be 42 inches tall.
Code is 42.
And are they making them higher? What are they doing?
No information that I have has shown a specific height
Are they
to.
Sorry. Please continue. Continue.
No information that I have has shown a specific height, nor. I mean, the locations are there, but again, it's going to be determined by the overall equipment location and where they are forced to be. So we do have a bit of a unknown here. In Peter?
I don't want to interrupt, go ahead.
I would just say we have a bit of unknown until we first and foremost determine the exact location of all the mechanical. That's going to take the precedent.
But you wouldn't approve a fence that was 10 feet tall if you needed a safety railing that was 42 inches?
Absolutely not.
Right,
no.
okay.
The intention is to have them 42 inches.
Okay.
That's what's
Thank
code
you.
minimum.
Thank you.
And so maybe this has pre-answered my next question. Are the proposed railings the absolute minimum necessary to provide safety for the workers, not to be another architectural feature? And so you,
Yeah, they're just a single line rail.
okay,
This is really, if I'd have known I'd get in so much trouble for putting safety rails up there, I wouldn't have done it.
no,
but
they're.
Sometimes we don't have them and the code official makes us put them back in. So I just thought it was a prudent thing, especially when we had, at one point, we were thinking about doing the solar panels, and there would be a lot of activity up there, making sure they're maintained properly. And so that's the reason why we had them up there.
Great. Same question that I asked you a minute ago, Matt. Is there anything about safety rails that I should have asked you that I didn't ask you?
Maybe the coloration, maybe. No, I don't believe so. I think you've got it.
But you're comfortable at this point with both the safety railings and the antenna as presented at this, where we
I'm
are?
comfortable in the aspect of requirement.
Requirement, okay,
If they're required, then I'm comfortable with it. If they're not required, then we need a variance.
okay.
You done? Hang on.
I'm finished, yes.
Okay, go ahead, Jen.
So we really just want a motion to say they don't need a variance because essentially is that correct, Fred? You're shaking your head, yes.
Yes.
Yeah,
So-
we will get there. I just want to make sure.
Oh, okay, I'm
You
sorry.
asked your questions?
No, that was my question. I'm trying to, I have tickets to it.
Oh, I'm sorry. And Bill, do you have any questions?
I have no question. I do want to say on the record, I do think that as a policy matter, if we're comfortable with the city's interpretation, not saying that somebody has to get a variance for safety railings just strikes me as the right position for us to take, because we sure don't want to be sitting here that some worker's been blown off with the wind we get.
Yeah.
Because as the architect said a minute ago, if he'd known there's going to be this much problem, we do not want to create more problems for people, to create safety positions for the workers.
Absolutely.
And I do not have any questions for the applicant or for the building inspector. So at this point, we have to open it up to the public we're going to combine antenna and railings. Is there anyone who wishes to speak? Okay. As far as deliberation, or yes, we could move to a motion if there's any need to deliberate these topics?
I don't need to deliberate. I'd be happy to
ready
make
to
a
vote.
motion.
You want to make? All right, Jan, go ahead.
Okay, I move that we accept the antenna and the safety fence rail as not requiring a variance.
And affirm the building inspector's.
And
Yeah.
affirm the building inspector's decision?
Yeah.
I don't think building inspector made a decision, but anyway, okay.
Okay.
Second.
Second, okay. I'm going to start. Bill, you're in for,
I support the motion. I believe that the building inspector's interpretations make sense both as a matter of the code language and as a matter of public policy.
Jan? Thank you, Bill.
No, yes, I voted for it. I mean, I made the motion, so yes, I'm voting
Okay.
for it. Thank you.
All right, Edie?
Yeah, I'm in favor of both. I think the building inspector has interpreted the code correctly, and I'm happy to affirm it.
And I vote yes also for the same reasons as Edie.
And I vote yes for the motion for the safety of the railing, and in agreement with Matt that the antenna does not need a variance. So that's a unanimous approval of that. And I think at this point we have to discuss, are we able to move on? But okay, go ahead.
Okay, there were three other items that hide in other
Oh, yeah,
things.
let's get clarification on that.
There were three other items that were mentioned throughout some of the
Evidence.
the evidence,
Yeah.
and I wanted to confirm. This is a question for the applicant, and then I'll ask the building inspector too. The cupola is 50 feet higher than, and it's 1,898 square feet. That's correct? That's what you understand too, Matt? Is that true? Yeah.
Correct.
And you have no problems with the cupola?
I don't.
Okay. And that whole statement about aggregate of the bases in terms of deciding about its size, that doesn't concern us?
It doesn't concern me.
Okay, well, if it doesn't concern you, okay. And I have questions about then the planters. The applicant, as I understand, dropped the request for planters in the August 23rd, 2024 footnote number 1. Is that correct? And that's still true?
Yes, I mean,
Am I asking a question?
we dropped the planters, we dropped the solar panels. I mean, we wanted to keep it as simple as possible when we
Okay.
came back to you, notwithstanding the fact it's taken us so long. But
Okay.
But we kind of stripped it back a little bit. We thought they were a nice touch. We thought they were a nice feature. We thought they were exempt, but, we won't do it.
Okay, I'm just verifying evidence. And building inspector, you had no further information about the planters?
Correct.
Other than that? Okay, and I've confirmed. And then the solar panels was the same question, that they were dropped on August 23rd, 2024 in footnote number 1?
Yes,
Yeah.
yes.
And building inspector, nothing to go?
Nothing
And we've
further.
confirmed. Okay, those were my three items that had been mentioned as possibilities of part of this. I wanted to be sure we were all still on the same page about all of these things. Thank you.
All right, so at this point, I think, we did not get to the variance request, so I always make sure I get the wording right. Are we looking at a continuance into October?
Well, is that the body's preference
add-
that we not move forward? And I mean, I'm not judging that, I'm just saying is.
My vote is to not move forward because I have to be somewhere.
Okay. So is there anything, we have the parties here, is there anything that we can accomplish with Mr. Forston here? Do we have any questions or anything?
I do have one question, if now is the time to ask it. On the variance that they're requesting, are they I realize that it's the hotel that needs the variance. Are they asking for a set number of spaces, or are they asking for the entire parking lot to be usable?
So I'll give you 2 minutes, and then I appreciate that we're going to have to continue this conversation at another time. When the Bellhaven came before the Board of Adjustment in 2021, it showed 116 rooms. It showed parking underneath like we have now, and it showed off-site parking where we're proposing it now. At that time, we believed, and the previous building inspector had told us that was permitted. Nobody had flagged it as an issue, so we did not ask for any variances associated with that. During the Planning Commission process, as I said in my letter, it's arguable, but I will concede the point, and we're asking for a variance. So obviously we're conceding that because hotel rooms are considered commercial or dwelling units, and because in fact the city has on 2 previous occasions actually granted variances for off-site parking for hotels, we are.
Simple question. We'll just hold it off the question until the new meeting.
So the answer to your question is, we want 116 rooms max. That's all we've ever asked for, and that would be the parking spaces on site and the parking spaces at offsite. But that was what we originally presented in 2021. That's what we would like to get permission for.
Even now?
Yes. I mean, when you think about it, we just lost 25% of the rooms going from 116.
But I thought your plans were 92 rooms.
So we made revisions to the plans to the Planning Commission, and so if you are gracious and kind and grant the variance to us, we will have to go back to the Planning Commission, and we're not disputing that. We'll have to show them the site where the off-site parking is. There may be tweaks to the
Discussion needed.
plan.
Right?
But
More discussion needed.
anyway, that's the situation with the off-site parking.
We're riding in a new boat.
And I just would ask Matt, I mean, maybe you think the code doesn't require you to post a sign on the street on Baltimore or to notify those neighbors, but I really do think that it would be appropriate, considering all of the stuff that's going on Baltimore with the new hotel, going part of the way down, you've got the restaurants, you've got the lifeguard station, and I think the people that work and own property on Baltimore Avenue should be notified that a variance for that parking lot has been requested. That's all. I think notification, I mean, I've just been through lack of notification myself. I think notification is important.
We will certainly look into our code and see if it is required.
Matt, I'm not asking if it's required. I'm saying, would you do it? Would the city be willing to notify the people who own the property?
Well, that sounds like it could be a conversation that could take place after we convene the meeting. So what, are we ready?
I did have one question I wanted to ask, and if it's going to take too long, I certainly want it brought back or as something Matt can look into. Code 270-35 does not discuss measurement by walking distance. I tried to find some code that said walking distance, linear, could not find any code, but I do understand that we use a radius tool for notification, as Ann uses it to notify people. I was curious as to, if you can answer quickly, why we don't use a radius tool, which would then make the remote parking spot compliant. It comes in around 500 and some feet.
Well, I was hoping to get into this during the conversation of the
Yeah,
variance.
should we defer it? Should we
and
just defer it?
I would like to defer
Okay.
that.
I'm fine. I do want to give that time.
Yes, I think we need fresh heads.
I
and
have
come
the
in-
answer.
Absolutely.
I just wish to be on topic with it.
Okay.
Sure. Good thought.
Okay, so a motion to table today's meeting with the understanding that the record will be open for those who wish to testify or any additional materials to be submitted before it's rescheduled at our next regularly scheduled meeting. I believe. Is that okay?
So, yes.
Yep.
Okay. Motion to.
What he said.
Yeah.
Mr. Chair?
Yes.
I'd like to interject.
Okay.
Edie asked to see what changed from 21 to 24.
No, that isn't what I asked, sir.
You wanted to see what,
I wanted to see just a new picture.
well, let me show you.
Okay, well, I saw those. I mean,
Okay, well then.
She wants to see a picture without the solar panels.
yeah, I wanted to
Oh,
see what
I
it really
see.
looks like, and I couldn't find anything more recent. But thank you for trying to meet my request. I do appreciate that.
I'll stand
But
down.
I did know the dual panel, and I read everything 2 or 3 times, so I've read it all and I've seen it all. But I just didn't see the most recent. But thank
That
you,
is the
sir.
most recent
Okay.
on the left.
Okay, all right.
And when would our
Thank
next
you.
meeting be? October, what's the date, so everyone here? 25th?
I'm willing to, if people are willing to meet sooner, I'm willing to meet sooner. We did that before. I'm sorry. I'm sorry.
Yeah.
Oh, you have.
Yeah.
Oh, okay. How did we do it when we did Bahia Bob? Because
Well, we didn't have to, we didn't have to re-advertise, but you're saying you want to re-advertise. That's what Ann is referring to.
oh, no, I don't think it's,
The
to send,
signs were on the hotel lot. There were signs, but they were on
Yeah.
the hotel lot. They weren't on the.
they weren't
parking lot.
on the Baltimore Street
No,
lot.
right, they were on the
So-
hotel
So,
lot,
you
right.
know, if you're not
Can
walking
I
over there.
suggest that we don't, I think it's clear in the city's view that it isn't required. Jan is asking it as a matter of
Courtesy.
accommodation. I don't think we have to have 30 days for that. If we wanted to meet earlier, I don't know whether we got time to do that or not, but since this is not a required notice, but simply additional letting people know on Baltimore, that I would think if we did have a time to be able to get them on short of the regular October meeting, we should be willing to do that since they've been waiting a long time. But if Matt decides that he's going to put up the notices, if they got 5 or 10 days' notice, they would, this is just being done as an accommodation, not because it's required by city code. I don't know whether we've got
We had
time
the
or not.
28th was what we decided for.
Is our,
I just checked my calendar.
So if we wanted to hold it earlier, we could because we're not bound by the notice requirement.
That's what I'm suggesting,
Right.
Fred, that's all.
Good point.
Do you want to talk about another date with the applicant?
We may run into a problem because it's parent commission,
Right.
because they're due to be scheduling some special meetings, so I would have to check their calendar first.
So do we want to endeavor to schedule the meeting sooner if possible? And if we cannot, then our fallback will be at our next
28th.
meeting.
right.
So
I-
we'll,
I would do that, Fred.
yeah, so
I-
we'll
I'm
make an
perfectly willing
effort,
to do that.
we'll make an effort to see if we can find a date that works for everyone, recognizing that that may be difficult. And if we can't do that, then we'll meet as
The
our
28th.
regularly scheduled meeting.
Right.
Fallback.
And do we have any other cases on the 28th coming up?
Two?
So it'd be really good if we,
Oh, yeah, it'd be good if we
if we
can do
can.
this first.
Yeah. Okay.
And I would just add, if you just, hammer in that orange sign over on that lot, if you don't even have to notify all the neighbors, but I think there needs to be some notification of the people who live on Baltimore Street and work and own businesses.
Okay, with that, I think, have a motion to adjourn today's
I
session.
move we adjourn.
so second.
All right, all in favor?
Aye.
Aye. Thank you, everybody.
Thank you all.
Thank you.
Bye, everybody.
Yeah.